Well, welcome to Uncivil Law, where we do, in fact, learn from the misfortunes of others. That tagline continues to be prescient every single day, which maybe is the best tagline in the history of LawTube, perhaps entertainment, learning from the misfortunes of others. Today's misfortune, Lexus is in space. Lexus is in space is a possibility. It is a possible. It is possible that the Lexus could go to space. Now, this will come as a surprise to not only Americans, not only America circa, say, 1960, but will also come as a surprise to many cultures throughout history, ancient cultures, medieval cultures, and even older cultures in Europe, China, India. I'm pretty sure some South American countries wanted to get to space and found it to be somewhat difficult. Uh, then when America decided we should go to the moon, uh, there was some effort that was involved in that enterprise. It was not, just there were plenty of cars that existed, although not Lexus. Lexus hadn't been invented yet, so maybe that was the problem. But there were plenty of vehicles in circa 1960. Maybe that 1957, that 1957 Cadillac just isn't cutting it. Did they try using a Duesenberg? Those are cool. You know, some maybe one of the maybe one of the now more obscure American makers. Some of those names that are somewhat lost to history. That I don't necessarily remember off the top of my head. Which car brands from circa 1930s to 1950s America do you think would be best for space travel? Please provide your answers in chat. Yeah, but in any event, apparently the circa 1930s to 1950s cars did not have the ability to go to space, or at least America couldn't figure out how to make them go to space because we had to invent a rocket and shit. Something about getting things into space requiring a lot of energy. See, there's this thing called gravity that holds everything down, and things go up must come down unless they go so far up that they don't come down anymore. And you have to go pretty far up so they don't come down anymore. And to move something requires energy, right? I mean, this is not that hard. If you want to move, say, you could measure it in terms of horsepower. Like, what is a horsepower? It's been a while since I've looked it up. It's the amount of what is it exactly? It's the amount of power that one horse could use over what is it like 1 hour to elevate like 1,000 pounds, like 100 feet or some bullshit like that. It's something like that. What a horsepower definition actually is. Say like the amount of power to elevate like 100 pounds, 1,000 feet or some bullshit. That's like the definition of a horsepower. So that's no problem. Like all you have to do then, once you figure out exactly what a horsepower is, or you remember what it is, then you just have to just do some math, right? It's like, okay, well, I have a 6,000 pound car, and instead of moving 1,000 feet, I want to move say 100 miles to get into like you know what could be categorized as space, and then how much horsepower is that? It's a fairly big number. How are we generating all this magical horsepower? There are not enough horses. Also, horses are not actually really good at generating horsepower. The average horse only generates something like zero point 0.7 horsepower. So it's actually a weird definition because horses actually don't typically have enough power to generate a horsepower. They actually like only generate something like zero point 0.7 horsepower typically. So the definition's wrong, but whatever. Anyways, pressing on with all these magical questions, magic Lexus in space is a real issue. Mr. Paul Vox says it's a fun subject, but getting old. Mr. Paul Vox, I have never disagreed with someone in chat more than I disagree with you now. You feel like this subject is getting old? You feel like maybe I'm beating a dead horse? Dun dun. Shh. I disagree. The horse is not dead, or at least it's not dead enough. We will continue beating this horse until it stops being amusing. Good times. Yeah, man. The magic space Lexus. And also, we ran some calculations, and ChatGPT reminded us that there are some problems with the magic black hole theory, which I was well aware of, although I had not explicitly mentioned it because it's not fun. But yeah, ChatGPT rained on our parade by reminding us the magic black hole would have problems both for the SUV and the Earth itself. That the magic black hole that would have enough gravitational pull to get the Lexus into space would also have something like 60 million G. And ChatGPT points out, fairly correctly that 60 million G might have some problems relating to the structural integrity of the Lexus. Yeah, I mean, Lexus probably tests their car to. I mean, I wouldn't know for sure, but they probably test their cars to maybe dozens of G. That wouldn't necessarily surprise me because in a motor vehicle accident, when you're talking about like sudden impact forces, I mean, I don't know what the total number of G is, but you probably get up into thousands, tens of thousands actually when you talk about like short impact times. They like 10, the equivalent of like thousands of G. You probably in very short time frames. So yeah, I mean, Lexus probably has experience with thousands and even tens of thousands of G, but I'm not sure they've experimented with 60 million G. That might present some problems on the structural integrity of the Lexus. Also, the structural integrity of the Earth itself. So that there are issues. The Earth, neither the Earth nor the Lexus may survive the magic black hole, but in some sense, I suppose Lexus achieves orbit of the now not the no longer existing Earth. So if the Lexus, disintegrates from the G forces and the Earth disintegrates, did the Lexus make it into space? Maybe that's a philosophical question at that point. I don't know. There are issues. Also, of course, the evaporation of the black hole itself. When the black hole evaporates, will release so much energy that also will present a problem. There are many issues with the black hole, but the gravitational forces and the evaporation of the black hole and the energy released. But in some sense, the Lexus will have achieved space travel. In some sense, I guess. Hmm. So yeah, the magic theories are a bit problematic. Yeah, 0 point energy is real. Okay, yeah, yeah, that could do it. Or yeah. See, even if it's a dark matter black hole, so that all there is gravitational effects, the gravitational effects are still a problem. Because the nice thing about dark matter, at least as it's currently hypothesized, although I somewhat doubt the existence of dark matter on a personal issue. I don't. I'm not sure dark matter itself is actually real. Actually, to be fair, neither the scientists aren't even sure dark matter is real. They know something's going on, but dark matter is just basically a placeholder for we're not. It's basically a we don't know button. I don't know that it's dark matter, something else. But in any event, if it is in fact dark matter doesn't interact with other matter except through gravity. It's the only way it interacts with normal matter. So it will phase through normal matter, but it still has gravitational impacts. So yeah, even the dark matter black hole, although the evaporation of the dark matter black hole will no longer create the force of 10 bajillion atomic bombs, the gravitational forces are still going to be a real problem. So yeah, there are many issues, but apparently, or aliens, or teleportation, or Harry Potter with apparition. One of those things. But apparently, there is some possibility Somehow the Lexus could somehow just achieve space travel. Okay. Nah, man, so that's fun. Good times. Is it considered on topic to say good morning? What the fuck kind of a question is that? Jay Tizzo, fuck off. Give me a break. Don't ask stupid questions. Jesus Christ. Did anyone point out my video title date is incorrect? Is it? It might be. It is in fact the 29th. You are correct. No problem. We will fix it. We have the technology. Ta-da! Great. Excellent. Achieved. And it's day 23, right? Not day 22. See, how did I mess this up yesterday? Is my thumbnail right? My thumbnail's right. The just date and tell is wrong. All right, no problem. Fixed. It was a recently added rule. No, it hasn't. No, it's not. Stay on topic has been a rule for quite some time, Jay Tizzo. It is. It is not a new rule. It has been a rule for quite a while. They're arguing this morning. Yeah, you're learning so much about me today. Hopefully, good things. Hopefully, you're learning good things about me today. Yes, it's only a half day today for some reason, and Bev would ideally like this witness off the stand by the end of the day. Which, to be fair to Bev, I totally understand her desire. That would be nice. Although this is a pretty critical witness for the defense, so I'm not sure the defense is necessarily going to make be able to make her dreams come true because it's like, yeah, I mean, yeah, 0 point Lexus Fun Rule 14 of chat. Nice, thank you. How was improv? Improv was fine, thank you. Our group went out for dinner last night too because I'm in a new group. Our previous group had gotten too small. We were down to like 4 students, which is not really workable. And now we joined another group and now we have like 12, which is a little large, but we learned the Herald last night, which is a form I've done before in a long form format, and 12 people for a Herald is very workable. So, I'm pretty excited about learning more about that. So this entire series of classes in level 4 has been about learning long form formats. So we learned about something called Slacker, which is just basically a series of tag outs. And then we learned about something called La Ronde, which is basically maintaining well, no, in Slacker, actually, there are no tag outs. How does it work again? Anyways, because there's no devices in Slacker. I've confused myself. It's too early. Anyways, we learned something called Slacker. Then we learned something called La Ronde, which is character driven. Then last time we learned about monoscene, which is just a really long scene. It's now a 20-minute long scene. That was kind of painful, to be honest. Didn't really enjoy that. Then last night we learned about Herald, which is a very classic long form improv format. So I'm excited. I've done Herald before. I did it in DC. So I'm looking. It's been a hot minute though, so I'm looking forward to doing it again. And to be honest, somewhat learning it again because it's been a while. But yeah, it was fun. And then all went out to dinner and we had a good time getting to know my new classmates. There's some interesting personalities, which is nice. You emailed me, please answer. Well, okay, when the court thing starts, I'll check my email. Let me get the court day starting, and I'll check my email. I checked my email last night. So if you've emailed me since yesterday, then or since last night, I haven't checked my email in like the last 12 hours because I've been asleep. But we'll get there. I'd be fun to hang out with. Thanks. That's very nice of you. So I'll describe Harold if I can. It's a little hard to describe. Well, I don't know if it's that hard to describe. Basically, what it also requires a really good memory, which can be challenging. So basically, you have three scenes that are kind of independent. So you start with three scenes that are related to an opening, and there's a lot of different ways to open. You could take a suggestion from the audience, and there's other ways to open. But basically, you do some sort of opening to pick to drive the similarity. So it could be a lot of things. But let's just suppose we take a suggestion. The suggestion's like pineapple. So you have three completely independent scenes that are in some sense related to the term pineapple. So they could be, anything that's related or it makes you think of. So then you do scene one, you do A1, B1, C1, independent scenes. Then you do a group game. Then you do A2, B2, C2. So you take the idea from, A1 and you figure out a way to elevate it. And then you do another group game. And then you do A3, B3, C3, in which you elevate from level 2 to it's sort of heightened. So you start off sort of, normalish at A1 so that you can elevate to A2, and then A3 you kind of take it to maximum absurdity, right? And then also on the third beat, you can also combine or bring in elements from the other beats. So the stories can somewhat merge. So at A3, you can bring in characters from like B or characters from C or elements that so they somewhat become less distinct at level 3. And that's, and the real challenge is of course remembering what happened at all those levels and stuff. So
All right, Mr. Lessie, I will hear you on your argument on the voir dire.
so hopefully that makes some sense. And we can break out a chart or something to make it a little bit more explainable because that was not necessarily the best explanation that's ever been provided.
Your Honor, I am going to address the Trooper Paul aspect, and then I'm going to address the Dr. Skirty Bellow aspect of Dr. Welcher. With regard to Trooper Paul, I would like to draw the court's attention to the following documents for the straightforward proposition that Dr. Welcher has not only reviewed, he has not only considered, that he has adopted. I went back and looked at the documents, and the basis for this is as follows. Slides 22 and 23 do not just depict Trooper Joseph Paul himself. They show Trooper Paul conducting the CARS analysis on February 1st of 2022. Importantly, these slides highlight the mileage odometer of 12,665, and I respectfully request the court to anchor into that odometer reading because I'm going to show the path that odometer reading takes through all of the documents, but I want to emphasize the genesis of the odometer reading of 12,665 miles is with Trooper Paul as he conducted the CARS analysis on February 1st. Now, here's where Dr. Welcher comes in. Dr. Welcher then uses this key data point, odometer 12,665, as the basis, the starting point for his determination of the locations and times for the events of January 29 of 2022. Dr. Welcher uses his scenario analysis of Ms. Reed's travels, and that's detailed on slides 24, 25, 26, 27, and 28, to calculate and then deduct 36 miles from the odometer according to Trooper Paul on February 1st of 2022 to arrive at an odometer reading of 12,629, which obviously is different from the anchor I talked about of 12,665. So the assumed odometer of 12,629, again, is based on Trooper Paul's CARS analysis in slides 22 and 23, are then used as a tether, a connection to the events recorded by the VCH in the Lexus on the following slides: 28, 29, 30, 31, 32, 33, 35, and 36. I elucidate this and I explicate the slide numbers to show how many there are in Dr. Welcher's report that are rooted in the anchor point and then the change in the deduction of the odometer. So the events memorialized by Trooper Paul on February 1st, including the odometer reading, provide the foundation for Dr. Welcher's entire analysis of the VCH events. The entire analysis of Dr. Welcher's VCH events. That is the adoption aspect of what I started with. Two more points. In addition, Dr. Welcher testified on his voir dire that the image on the left of slide 36 from his January 30th, 2025 presentation came from a file marked carsj.paul. Now, he did contend that it wasn't the exact same image, but I want to go to this. In fact, the image on slide 36 is from the drone used by Trooper Paul, and the citation for that is page 4, item 11 of the CARS report. That's where the drones are from. Dr. Welcher didn't do any drone activity. He took the drone that he had in his report that was just a little bit different than the one I was showing him. It comes from page 4, item 11 of the CARS report. And I quote, "The crash scene was documented during the on-scene investigation by utilizing Alicia's GNSS GPS mapping system and a DJI Mavic 2 UAS. This data was input to a computer-aided diagram program, which is IMS 360, here's the key, to produce a scale diagram of this collision. So the DJI Mavic is the CARS team drone. This image of Dr. Welcher's slide 36 is clearly and indisputably from the drone. And the only drone extant is the drone of Trooper Paul and the CARS team. Last point with regard to the Trooper Paul basis in adoption of Dr. Welcher. Mr. Brennan asked Dr. Welcher on voir dire if the image from slide 36 actually came from the CERT team, which is simply not true. The CERT team, actually Lieutenant Tully with the CERT team, took about a dozen photos of the taillight in the snow, in the dark, around 6 p.m. on January 29, 2022. Lieutenant O'Hara said that the CERT team never traveled back to the scene again. So there were very obviously no photos or images taken by the CERT team in the daylight from the drone. And I again refer to slides 22 and slides 23, where Dr. Welcher said it was more likely than not that it was Trooper Paul in those slides, but the point, whether it's Trooper Paul or not, is completely overwhelmed by what I just argued and presented as specific factual basis for a review, a consideration, and an adoption of the work of Trooper Paul. Unless Your Honor has any questions, I would now move on to Dr. Skirty Bellow. Thank you. Dr. Skirty Bellow will be much shorter. Mr. Woke, do we have the slide of the Dr. Skirty Bellow that was, it's at the end of the slide presentation with her name on it?
The TV's off,
Oh.
but I have
If you just give the slide number, please.
131.
So it is slide 131. I almost know it verbatim, Your Honor, so I will continue if Ms. Gilman has slide or someone could turn it on. Okay, thank you. Thank you, Your Honor. So with regard to slide 31, at the very top, and this again is a slide presentation of Dr. Welcher. So up at the very top, and so Dr. Welcher admitted that he not only reviewed the autopsy report, he admitted that he not only considered the autopsy report, he admitted that he adopted it, and I'm going to put adopt in quotes, to the extent that he used it in his slide presentation, and he actually, to show the depth of those three verbs, he's got in orange highlight under final diagnosis, multiple skull fractures, base of skull, and cavallarium. He testified, obviously, about the rear wounds of Mr. O'Keefe. He testified about how he believed those wounds came about, and he cited as corroboration the highlight of multiple skull fractures, base of skull, and cavallarium. It couldn't be any more obvious, his rooting in this document and reliance upon it. Why else would he have it in his slide presentation? And he's got the name of Dr. Skirty Bellow. And frankly, Your Honor, he didn't fight that whatsoever in the questioning of him. Then you go to underneath cause of death, blood impact, injuries of head, and hypothermia. He essentially repeated that on his testimony. And then if we could, Mr. Wilk, just go to the right. And so you've got highlighted head, skull fracture radiating from the right occipital skull and into the right parietal bone, right and left occipital foci, and bilateral anterior foci and orbital plates. Again, the highlighted means something. He's adopting it. And lastly, the depiction of the skull here, I believe that's Dr. Welcher's handwriting. I believe that's his green, the LR, because I've never seen this green highlighting before. And it could also be Dr. Skirty Bellow's. That's another possibility. I'm not sure. But let's assume sort of the most conservative part that it's Dr. Skirty Bellow's. The key part is he's got it in there and he is referencing it. So, Your Honor, the last point really for both of them, and I wanted to save this point because it applies to both. With regard to experts, the law is clear. So I think the easiest part to show what our position here is the adoption. But in it, it's clearly shown. Adoption doesn't mean you have to agree with it. You just have to put your expert hands around it, wrestle with it, deal with it, and there is no rule of law that I'm aware of that says you can't question an expert witness unless it's something that the expert witness agrees with. If the expert witness has reviewed it and considered it, and especially if they've rejected it. The easiest is obviously reviewed, considered, and adopted. But it's certainly permissible and important to a defendant's constitutional right, Sixth Amendment to cross-examination, if an expert says or even infers, I reject this. I reject what Trooper Paul did, or I reject what Dr. Skirty Bellow did. That is decision-making of an expert that the attorney has a right to be able to test. Why did you reject it? What was your thought process in rejecting it?
Sounds right to me.
And that applies to both Trooper Paul and Dr. Skirty Bellow, because as I understand it, this witness, Dr. Welcher, is not, he says, I'm not relying upon Trooper Paul, which is completely false based upon what I just showed.
And even if he's not,
but even if he just rejects it, in addition to what he has done, we have the right to test and get answers as to why he did it.
Yeah,
and
sounds
the
right to me.
same with Dr. Skirty Bellow. Once he goes to this level, Your Honor, I believe it's a straightforward right, especially of a defendant in a criminal trial, and especially of the stakes and the charges this high, that we get to test it.
That sounds right to me. If it is something that he considered, whether he relied on it or not, whether he rejected it or not, it seems like something you could ask him about. And there might be very valid answers to that question. Like, did you consider this? Yes. Did you agree with it? No. Why not? Trooper Paul's a fucking idiot, right? I mean, there's nothing wrong with that answer legally, right? I mean, that's basically what ARCA will say, although they'll say it more, in more polite language. I'm sure if asked, right? Or if you can ask the question to ARCA too. Brendan can ask the question, hey, ARCA, did you consider Trooper Paul's report? I'm sure they did. Yeah. Did you rely on it? Not really. Did you agree with it? Not so much. Why not? He's a fucking moron. So, but they'll say it in more polite language. So yeah, why wouldn't you be able to ask that question? Well, I actually did some science and stuff, and they're a bunch of bullshit, and I'm the best thing ever. So, but why can't you ask the question? It seems like a reasonable question. Yeah. Okay. Yep, seems right to me.
I think, lastly, my point here, Your Honor, the Commonwealth is doing is this. The Commonwealth knows Trooper Paul and Dr. Skirty Bellow are problematic for their theory.
Problematic is one way of putting it.
Trooper Paul has got, if you work backwards from his key cycles, you end up with 1162-2, their key cycle. That ends up being not in front of 34 Fairview, but it ends up when the Lexus is in the possession of the state. That is the result of that. And that was something that was addressed square head on in the first proceeding. We're not coming up with some fanciful ghost in the second trial. This was gone through extensively in the first proceeding. And I understand this is a new trial, but it goes to show it's not something coming out of the blue, etc. And with regard to Dr. Skirty Bellow, it was remarkable on the redirect that I've never seen a prosecution essentially go after the opinions and conclusion of their own medical examiner when they basically said, the medical examiner, I can't call this a homicide. The manner of death is undetermined, And the medical examiner says, I don't see any motor vehicle impact injuries. There couldn't be anything more apt, more probative than whether or not the injuries to the decedent are from a motor vehicle. The Dr. Welcher himself is saying they are.
I agree with Alessi. For my money, I've said as much. Like the easiest way to resolve this for the defense, and Alessi agrees. It's like that the collision didn't occur. It's like, yes. I mean, they've been saying that the whole time. I mean, that was their opening argument. Not like it's a revelation, but yeah, that this collision did not occur, and even assuming it did, that it didn't create the injuries in question. So you're missing the actus reus or the causality, as the lawyers would say. The actus reus, the action never happened, and even if it did, it didn't lead to the injury. So you take your pick between actus reus and causality, and it's like, yeah, that's the easiest way to resolve it. And there are significant reasons. There are significant reasons to question whether this injury occurred from the car, and even assuming it did, even assuming the car hit him, that it then led to the injury. There are significant reasons to cast that into doubt. I would say those doubts are reasonable, and then you're just done, because that's the game, right? I mean, at the risk of stating the obvious, the state has to prove beyond a reasonable doubt each and every element of the crime. That the act occurred is an element of the crime. Causality is an element of the crime. Those are both elements of the crime. If there is reason to doubt those things, then you're just done. Either one, because they have to prove every element of the crime, all of them, to a reasonable doubt certainty. And it's like, yeah, so is it possible the car hit him? I suppose. I mean, that's a lot more possible than the car just winding up in space. That's definitely a lot. I would say there's more evidence the car hit him than the Lexus just winds up in space sometimes. So there's more evidence of that. But is there reasons to doubt it? Yeah, I mean, their own medical examiner says they don't see collision, no bruising. How does a taillight shatter? How does it create all those injuries? Blah, 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 blah. And then assuming, of course, you get past all those issues, because that's just the easiest way to resolve it. Assuming you get past all that, then we can get into evidentiary issues, bias issues, and a whole bunch of other grounds. But the easiest way to resolve it is that, yeah, the collision didn't occur, or at least there's reason to doubt that it occurred, and then you're just done. So pretty much, and we have every right as the defense to question the government's witnesses relating to anything they did discuss or anything they did consider. And if there's inconsistencies, which, sometimes happens, experts don't always agree with each other. The ME could be wrong. MEs aren't God either. So the ME could have made a mistake. It's not a great position for the state to be in, to question their own ME, but the ME could be wrong, and the ME's not God. And maybe maybe they can get past that, right? Maybe they can bet like this ME just made a mistake. The ME checked the wrong box. The ME was drunk that day. The ME just was, did a brain fart or whatever. And the ME just is a dummy. They did a dummy that day. It happens to the best of us, right? And maybe they can get past all that, but the defense is certainly allowed to be made aware of it. They certainly have the right to bring that out, and then they have the right to make the state justify it. It's like, we can't help notice that one of your own experts says they can't determine it was a homicide and that there was no evidence of vehicle crash. We can't help noticing that. You want to fix that to a beyond a reasonable doubt certainty? You want to do that? Maybe the state can do it. Maybe they can. But the defense certainly has the right to ask the question. And so they have the right to ask the question of this witness as the biomedical engineer, expert, PhD, Lexus space traveling guy that he is, and ask him about Trooper Paul. Maybe Trooper Paul is an idiot. That is a perfectly reasonable answer to this question. Trooper Paul is an idiot, and his conclusions are dumb and are best ignored. That might be a perfectly satisfactory answer to the question. But why don't they have the right to ask the question and make the state try to justify it? I don't know. And so, yeah, even if he rejected it completely, it's like, it's their witness. You figure it out. Yeah, I mean, makes sense to me. So Alessi Unless he's spitting some truth bars this morning, I'm on board.
That's the essence of his opinion. It's the essence of his test. We get to be able to, respectfully, Your Honor, say, well, wait a minute. You said you looked at the autopsy. You said this. You highlight it. But you're going against the medical examiner on whether there's motor vehicle injuries. The experts can't, Your Honor, cherry pick and choose from documents. They can't use it as a shield and a sword. They can't put up, for example, Dr. Skirty Bellow's autopsy report, cherry pick things that benefit from them, and then and they did it on direct. And then all of a sudden not.
Well, I would slightly disagree. It's not that they can't, but they have to justify it, right? So experts can, and to some degree should, reject information. So you can call it cherry picking, but of course you then have to justify those choices. Like, why did you use this data and not this data? And there might be a perfectly satisfactory answer to that question. Some of the data might contradict each other, and so I went with the data was the most reliable, and here's why I thought it was the most reliable in my professional judgment. There might be an answer to that question, but yeah, it's not that an expert can't, but they have to justify the choice. And the defense has every right to be like, can you please justify the choice, please? Yeah, I mean, fair.
On cross, when we want to go and test that, they say, oh, no, you can't do it. Your Honor, this whole argument is absurd.
It's a little absurd.
It's antithetical to the Sixth Amendment. And even if, and this is my last point, even if this were merely a civil case, this would be routine cross-examination against the expert on the side.
Facts.
So in conclusion, Your Honor, I respectfully request that Ms. Reed and her team be allowed to exercise their constitutional right to cross-examination, the keystone of a defense in a criminal trial, cross-examination, and that they be able to take the shield that the prosecution is trying to put on us and be able to combat the sword that the prosecution has put forward with regard to trying to cherry pick from this information, and that we get to proceed, and we get to proceed undaunted from all the serial objections yesterday that interrupted my cross-examination. Thank you, Your Honor.
I tend to agree with Alessi. That sounds correct to me, Mr. Brennan. Okay, what you got?
What arises from the litany of complaints by the defense is that there is no constitutional right to usurp the rules of evidence.
Well, to the extent there's a constitutional right, that's wrong. I mean, we have to presuppose there is a constitutional right, which we could have a debate about whether or not there is a constitutional right. But if there is in fact a constitutional right, yeah, they usurp the rules of evidence. That's not complicated. Yeah. So that we're not starting off real strong there.
There is no case law, as much as they urge the court and yell out the word case law and constitutional right and Sixth Amendment right. There is no case law to support what they are trying to do. It is a simple endeavor that is clouded by all the rhetoric that they offer. And it is clear, and the court knows what they're trying to do. They are trying to pit the inadmissible opinion of a non-testifying witness against a testifying witness. They have asked.
Yeah. Well, yeah, but it's an expert witness, and he considered a lot of things. That's weird. Yeah, you ask the expert witness about a whole bunch of things that are not testimony, and yeah, that doesn't make sense. I'm confused by that. That doesn't make sense. I don't. All right.
Dr. Skirty Bellow what her opinion is. And although it's not consistent with our reading of the case law, they were allowed to introduce that it was an undetermined cause of death or a mechanism. That evidence is already in front of the jury, but they can't simply repeat it because it sounds good to them or they think it's helpful. Simply because a witness uses a document or looks at it or uses part of an autopsy does not let them regurgitate an opinion that's already in evidence to try to phantom cross-examine an expert.
No?
Dr. Welcher is clear. He did not rely on Dr. Skirty Bellow's conclusion that
Why
this cause
not?
of death was undetermined. In fact, as an aside, he said, I wouldn't, because she's not qualified for that.
The biomedical engineer expert said that the ME was not qualified to determine whether it was okay. All right, that's an interesting take. The biomedical engineer says the MD is not qualified relating to whether it was a vehicle accident or not. Okay, interesting take.
And so this is a simple game. Let's pit one witness against the other and suggest that the Commonwealth's witnesses are inconsistent. They take
Yeah.
it a step further. They want to relive what they think is their past success last year in this case without actually calling the witness. They want the jury to hear their perspective that a past witness had confusion in his analysis, but they don't want to call the witness. They want you to allow them to do that, not just shouting it out and have sustained objections, which has happened this entire case, but they actually want you to be able to allow them to ask Dr. Welcher these questions, which he did not rely on. We had a voir dire, he was clear. He did not
why didn't he
rely
rely
on the
on it?
analysis of Trooper Paul. He did not rely on that determination or undetermined determination by Dr. Skirty Bellow. It is that simple. They try to throw some fluff out and they throw around some documents. We have slide 22. Simply because there's a suggestion that Trooper Paul might be the hand in the picture is not an anchor, it's not a tether, it's not an adoption, it's no such thing. In fact, if you look at that photograph, it was taken
I'm not even
by
sure they
Zach
need the anchor or
Clark.
their tether.
So
to
by
be
the
honest.
rationale of the defense, they should now be able to ask Dr. Welcher any question they want about Zach Clark's opinions, efforts, what Zach Clark did. It is a photograph.
If Dr. Welcher reviewed that and in any sense considered it, even if rejected it, then yes, that would seem right. Right? Did you look at it? Yes. Did you consider it? No. Why not? Insert answer. Oh, okay. You know, I mean, okay.
That he considered. Not an opinion, not an analysis. It has nothing whatsoever to do with Dr. Welcher's analysis or opinions. In fact, the evidence is to the contrary. He came out, conducted an independent analysis, did all of the work himself, considered documents, and he was specific about what was part of his opinion and what was not, and this information was not part of his opinion. They turned to the Google map. Bit misleading. This was generated by Google. Two separate people used the same program, but when you look at the CARS report and you look at Dr. Welcher's PowerPoint, it's different. Dr. Welcher's has a map on the side, and when you look at the numbers themselves, the CAR report says minimum 36.1, maximum 38.8. Dr. Welcher's slide, 37.9, 38.1. So in no way did he adopt, anchor, tether, use as any basis. In fact, his is different and separate, as all of his analysis is. And so the portrayal of this necessity of information so they can sneak in inadmissible opinions with no witness is simply improper. There is no case law. There is no legal support for it. They cannot reach back into last year and manipulate a witness and ask him about something that he didn't rely on because it feels good or it sounds good for their case. Dr. Welcher did not rely on Trooper Paul's analysis or reports, and he did not rely on the conclusion of Dr. Skirty Bellow of undetermined. If they want to call Trooper Paul, well, maybe they can try to do that, but Dr. Welcher's not.
Maybe they can try to do that? They can try to call Trooper Paul? What do you mean they could try? What? What do you mean they could try? What the hell are you talking? What?
Not the right witness for it. These opinions to try to do a credibility eval is a core preclusion in criminal law, a court preclusion. You cannot vouch for the credibility of another witness. You cannot comment. It's like asking, did the police officer lie when he said the light was red? It's the absolute same analysis. It just has a lot of icing on it.
Well, you wouldn't be able to determine whether it was a lie necessarily, because again, a lying is a knowing, purposeful deceit. So an expert probably wouldn't be able to draw that conclusion, but they would be able to see based on my analysis, I reached a different conclusion, right? So if the cop, I don't know what scenario this is that we're doing, but if a cop said the light was red and you had some expert on the stand who's like, well, I did some sort of study, blah, 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 and I determined the light was green, you wouldn't be able to really ask the expert, was the cop lying? Because the expert wouldn't know whether the cop was lying. The really the best the expert would be able to say is, well, I just don't think they're correct based on so you wouldn't be able to ask, was the cop lying? You'd be able to ask, didn't the cop come to a different conclusion? Yes, I didn't agree with it because of all these reasons. And depending on how good those reasons are, then it's an issue for the jury, right? Like every issue, right? I mean, at the risk of stating the obvious, to paraphrase the standard jury instructions, you, the members of the jury, determine you, the members of the jury, determine the truth value of testimony and also the weight of the testimony. If you believe a witness is untruthful in part, you can believe they're untruthful in other parts or not. If you believe a witness is unreliable in part, you can believe they're unreliable in other parts or not. And then it's up to you to determine how much weight there is to be given. And maybe you get there. Maybe you can get there, right? The cop says the light is green. The expert says the light is red. And maybe there's reason to trust one over the other. And maybe beyond a reasonable doubt is fine, because it's like we can discount this guy or we can give credit to this guy because of various elements that would be apparent in the testimony. So but you still get to ask the question. So I don't know what Brennan is talking about. Brennan is confusing me, and it's too early for this.
Very briefly, start getting the jury ready, please.
Bring the jury. Oh, okay. Well, damn.
Your Honor, with regard to Trooper Paul, Mr. Brennan did not address 80% of the slides that
Heaven forbid that this judge, allow for full argumentation. And if the judge doesn't allow this, the legal reason is not apparent. Yeah, it's like if he considered it. Now, if he didn't consider it at all, then, fair enough. If he didn't consider it at all, but it looks like he did because parts of his slide might include things. And so it looks like he did consider some of those things. So if he didn't consider it, then, okay, maybe the expert witness didn't consider it, at least in principle. I just wanted to do something completely independent. I had a whole lot of other reports from other people, but I didn't look at it because I wanted to reach a completely independent conclusion. That might be something an expert might reasonably do, right? I didn't want to bias myself or taint myself in any way with other people's analysis. I wanted to do something completely fresh and completely new so that, it would be completely my own. That might be a reasonable thing. But it's like, if he considered it, then why did you consider it, and to what extent? And if you rejected it, why? And so forth and so on. Seems like pretty reasonable questions. So I think Alessi is right on balance. And if the judge disagrees, I don't understand completely why. Seems odd to me.
address that showed the basis. When he talked about the picture, making it seem like the picture is the only thing we're relying upon, there's clearly other items, but even the picture, Your Honor, the purpose of the picture is it's got the odometer reading. That's why they took the picture, and that's the tether. So the photo is completely relevant. It's not who's in it, it's the fact that that's the odometer reading they're using. Next point with regard to case law. Mr. Brennan presents none to go against the common sense law that has been there for years.
Common sense is not really a great way to...
is with regard to... Mr. Brennan keeps trying to put my arguments into a credibility, like we're trying to attack the credibility of Trooper Paul. He says that we're trying to redo last trial. To the contrary, Your Honor, it's the Commonwealth that brought Trooper Paul into the second trial through Dr. Welcher and Dr. Welcher's reliance on all the work of Trooper Paul. They've brought it in here, and because of that, we get the right to cross-examine it. Last point. This is not about credibility. He keeps saying something that's not happening, that we're going to attack the credibility of Trooper Paul. What we want to do is to say to Dr. Welcher, you have brought up Trooper Paul. You have used his odometer reading. That odometer reading tethers through to Google. It tethers through everything you're doing. It's the foundation. But what you're ignoring, Dr. Welcher, are all the key cycle results that come from that odometer reading that you relied upon. Dr. Welcher himself can't cherry pick, grab things that he needs from Trooper Paul to do his analysis, and then the Commonwealth say, but you can't go after that because it somehow has Trooper Paul's name on it. It's illogical, Your Honor, and it's incorrect under the law. Thank you.
Overruled.
So I disagree with you, Mr. Alessi.
Yeah.
I'm not allowing in the line of questioning regarding Trooper Paul, and I'm not allowing the line of questioning regarding Dr. Skirty Bellow. So that's my ruling. Let's bring the jury.
I don't understand that ruling legally. That seems wrong to me. That seems wrong to me. I'm always open to the possibility that I'm missing something. I'm not considering something. There's some nuance here that I'm not thinking about, but that seems wrong. Yeah, that seems error. That seems like an error. And it seems like a pretty large error at that. Because when you're thinking about it from an appellate posture, of course, not only does it have to be a mistake, but it has to be a mistake that has a material impact. And there's a lot of materiality in this because the inconsistent data is a problem for the Commonwealth. And the jury, of course, in the end, when exposed to the inconsistent data, as I mentioned before, like you, the members of the jury, have the ability to determine reliability, credibility, weight, and a whole bunch of other things. So in the face of inconsistent data, there are a lot of ways beyond a reasonable doubt that they might be able to accept one thing and reject another. So if the jury is presented with the inconsistent data and they convict, that may very well be a legally sound conviction, even if a different jury could come to a different conclusion, because of course we're trying to determine what a reasonable jury could do. And a reasonable jury in the face of inconsistent data and inconsistent experts conclude that some experts are more reliable? Yeah, there's a lot of ways to get there, but if they're not presented with the information at all, that seems like an error, and probably a reversible error at that, because it's fairly consequential. So I don't know about that seems wrong. That seems like an error.
Jury in. Well, come over here because they're on their way.
Sidebar. Yeah. And it's not that the expert can't cherry pick, that it's that you have, so unless he's slightly wrong, it's not that the expert can't cherry pick, it's that the expert, having done so, has to justify why that makes sense. It's like, didn't you pick, because that's like a difficult thing to justify, although maybe not, depending on what exactly you're doing. It might make sense why you pick some part of the data and not other part of the data. It might be, right? So it might make sense why you so-called cherry picked, but you have to justify that choice. And maybe there's an answer, but you have to justify the choice. I mean, you're the expert. Maybe it makes sense. Well, tell us why. Lord. What happens if there's a second mistrial? Presumably, we're on to trial number 3. The defense needs to call Trooper Paul to lay the foundation. Maybe they call Welcher. That's an interesting idea. I don't know that I necessarily would do it, although from a appellate posture, it'd be interesting to see the degree to which that like would be an error by me. But yeah, I mean, is some points is repeated attempts at constitutional violation? That's a great question, Eric, and we don't know the answer to the question. The Supreme Court was faced with a case in which there was it was like the 7th or 8th retrial or something, the US Supreme Court, and they didn't say it wasn't permissible, but they seemed grumpy. And there was no further retrial after that because I think the government got sort of the hint at that point. It's like, yeah. So the Supreme Court didn't say that there's any limit, but the Supreme Court of the United States did seem a little bit grumpy about the 7th trial. It's been a while since I've read that case. If we have a break in chat, maybe we could pull it up and reread it because it's been a while since I've read it. And so, yeah, how many times can you retry? It was a case, and yeah. Yeah, it was some number like that. I forget exactly what the number was, but it was fairly high. We could read it. It's been a while, so it'd be good. Yeah, 2022 sounds about right. It was a very recent case. Yeah, that sounds right.
Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
Good morning, members. I do appreciate you were waiting. We were doing work in here, but we appreciate your patience. So I do have to ask you those 3
You can retry as long as you want.
All able to follow the instructions and refrain from discussing this case with anyone?
Yeah, I don't remember it being quite that clean.
Were you also able to follow the instructions?
They didn't say it wasn't permissible, but I'm not sure they exactly said it was either.
Everyone said yes.
I don't remember it being quite that clean, but we could reread it and double check.
Or read anything about this case since we left yesterday? No. Everyone said no or shall be. Thank you. Could we have Dr. Welcher back in, please? And Mr. Leslie, feel free to go to the podium.
With the computer and any electronics there, so we don't have to address it.
It doesn't look like it's turned on at all.
Oh, okay, good. And smart watches.
Smartwatches.
So this one.
Sir, I'll remind you, you're still in the room.
Thank you. Good morning, Your Honor.
And Dr. Welcher, we're going to ask you to not turn on your computer yet.
Okey-dokey.
Thank you.
And Your Honor, if I could, smartwatches that are receiving text messages during his direct, if we can make sure that that does not occur.
I can get my email number on. I'll take it all the time.
Okay, or just don't look at your watch.
I'll split it, okay?
Okay.
Thank you, Your Honor.
Yeah, no
Morning, Dr.
coaching
Welcher.
on your watch.
Good morning.
No watch coaching.
Do you know whether there was glass found on the bumper of Miss Reed's Lexus SUV?
It's my understanding there was, yes.
Did you reach a conclusion on whether the glass on the bumper came from the drinking glass that you assert Mr. O'Keefe was holding at the time of the alleged impact?
I didn't have an opportunity to inspect the glass, but the glass was broken and there was glass on the bumper. That's all I know.
So you, as you sit here today, you have no basis to conclude that the glass on the bumper came from the glass that you depict as having been held by Mr. O'Keefe at the time of the alleged impact. Is that correct?
Well, you're mixing a couple things.
No, Dr. Welcher,
So can
if
I-
you can just answer my question.
I'm
If
trying
I
to.
need to rephrase it, I will. I'll ask it a different way.
Please.
You have no basis, as you sit here today, to conclude that the glass on the bumper came from a drinking glass connected to Mr. O'Keefe, do you?
Well, we have a picture of a broken glass at the scene. So I wouldn't say we have no basis. We don't necessarily have enough to conclude it's from it, though.
Do you had depictions in your test with Mr. O'Keefe holding a glass, correct?
Correct.
My question is, you have no evidence to show at all other than, and I'm talking evidence, testing information. You're saying you have no evidence that shows that the glass on the bumper is not the same glass as you showed on your slides as being found supposedly at the scene. You have no test evidence that that's the same glass, do you?
So again, the one I have at my testing obviously was not the same glass. We have pictures of a broken bar glass in the snow near where Mr. O'Keefe's body was. We have glass fragments on the rear of the bumper. That's the extent of my knowledge on the correlation between those two.
So, do you said you reviewed the reports and testimonies of various Commonwealth representatives, correct? That's in your report.
Correct, in the initial.
In the initial, right, correct. And some of those reports included forensic scientists who work for the Massachusetts State Police, correct?
I believe that's correct.
And you put those in your report as documents that you reviewed, correct?
Correct.
And as you sit here today, it's your testimony, you don't know whether in any of the reports of the Massachusetts State Police, there is an answer to the question of whether there's any connection at all between the glass found in the snow and the glass on the bumper.
I recall it being inconclusive.
Oh, so you recall that the testing was inconclusive?
I don't remember what testing they did, but for example, when they put the taillight fragments back together, they were able to deduce that the fragments were from the taillight. I don't think they attempted to do that with the glass.
Assume that there has been testing of the glass on the bumper, and assume that that testing conclusively determines that the glass on the bumper is not the glass that was found in the snow.
Okay,
Assume that.
okay.
How would that affect your analysis?
I'd want to know where the glass came from, but we still have a whole bunch of other elements. So I don't think it would affect the end results.
So, would it have any part in your analysis with my assumption that the glass on the bumper is not the glass that's associated with the broken glass that was supposedly found in the snow?
Yes, I mean, we always want to have as much answers or as many answers as possible. So I would want to know if we could figure out where it came from.
And wouldn't the fact, assuming that the test results show there's no connection, meaning the glass on the bumper is different from the glass in the snow, wouldn't that be contrary to your theory of what happened in some way?
It depends on when the glass was actually broken. The glass was in his hand, at least that's the testimonial evidence I have seen. So it depends on whether it's broken from contact with the rear of the vehicle or broken with contact on the ground.
Assume that the glass on the bumper is not the glass that was found in the snowbank. Doesn't that, at least in part, contradict your hypothesis as to whether there was contact by the Lexus with Mr. O'Keefe at 34 Fairview?
So if you recall on my slides, nowhere did we discuss that in my slides. So no, it wouldn't contradict it. I would want to know where that glass came from.
But you didn't seek that information, did you, sir, in your analysis to determine where the glass came from?
Well, of course I did. I read the reports about it.
But you sit here and you say you don't know the answer. There's steps you could have taken to get that answer quite easily. Couldn't you have, sir?
Not me. That's a material science expert.
You've been communicating with Lieutenant Tully, haven't you?
Correct.
You couldn't have asked Lieutenant Tully that question?
To my knowledge, he's not a material science expert.
But could he have told you the result of testing on that glass on the bumper and whether it was any way associated with the glass found in the snow? Wouldn't that have been an easy question to ask him? Just, has there been testing, and if so, what's the results?
Yes, but my knowledge from reading the reports was it was inconclusive.
But you didn't read all of the reports, did you, sir?
Apparently not.
Let's turn to another topic, laser scans. Part of your analysis involved conducting laser scans of portions of 1 Meadows Avenue, the house of Mr. O'Keefe, correct?
Correct.
Those laser scans were used, at least in part, to answer the question of whether the collision between Miss Reed's SUV and Mr. O'Keefe's Chevy Traverse at 1 Meadows at approximately 5:07 a.m. on January 29, 2022, caused the right rear taillight of the Lexus to break, correct?
Correct.
And in that analysis, inches literally matter, correct?
You want to get it as accurate as possible.
And the reason why inches matter is because, and we're going to get to this, you try, and you did it in your slide presentation on direct, you tried to see whether the Lexus lined up with the Traverse such that there could be a break of the taillight. That was part of your analysis, correct?
So the main part of the photogrammetry was to determine the speeds and the angles and the degree of overlap on the vehicles. And then we also looked at the damage from the video, or actually it's just where the snow was knocked off the rear of the Chevy Traverse, and document the height of that.
You said the main part. I don't want to engage in semantics. I want to go to my question of, isn't part of the laser scan analysis to determine whether or not those two vehicles align sufficiently such that the Lexus could break, the taillight of the Lexus could break coming into contact with the Chevy Traverse? Wasn't that part of your analysis, at least in part?
Yes.
Okay. And in that analysis, inches literally matter, correct?
It can, depending on which way you're going inches.
So the ring camera at 1 Meadows, you're familiar with that ring camera, right? At
Correct.
1 Meadows? That ring camera at 1 Meadows was used as part of the laser scan process that you and your firm Aperture performed at 1 Meadows on October 2nd, 2024. Do I have the date correct?
I believe so, but like the videos were not literally used during the laser scans. We took the laser scans, the video, combined them together in a process called photogrammetry.
Okay, let's get this down to the fundamentals. You used, and that was my question, Your Honor, if we could publish the exhibit with regard to the ring camera.
Sure. What exhibit is it?
Yeah, I've got my page, yeah. Dr. Welcher, you recognize that ring camera as being at 1 Meadows. You discussed it, as a matter of fact, on your direct testimony, correct?
Yes.
Now, that ring camera was utilized as part of your laser scan process, correct? It was used.
So you're confusing laser scan and photogrammetry. The video, the laser scanners are together used in the photogrammetry. The camera and the laser scans are not used necessarily with each other.
Was that ring camera used for any part of your work?
Absolutely, the photogrammetry.
I just need to be able to finish my question, sir. Was that
sorry.
Ring camera used for any part of your work at One Meadows on October 2nd, 2024?
Yes.
And it was used for what purpose?
In the photogrammetric process, to establish the position and dimensions of various things in the video. So then we could go back and overlay the vehicles and track the tracks in the snow, as well as look at the damage to the vehicles.
Right. So this was used as a basis, not the only one, to establish dimensions of the other work that was done in analysis at One Meadows, correct?
Correct.
You can take that down, Mr. Wope. You know that the Ring camera at One Meadows, in existence when Aperture did the work on October 2nd, 2024, was different than the Ring camera that was in existence on January 29th of 2022, the date where you went through to see if those two vehicles align. Is that correct? The cameras are different.
That is correct.
And you know that the cameras are different, and you knew that as part of your analysis, correct?
Correct.
Did you document the differences between the two cameras as part of any work performed at One Meadows?
Yes.
And did you measure any differences there might have been between the location of the newer Ring camera from the older one that was in existence on January 29th of 2022?
No. What we did is use the current Ring camera in conjunction with the old Ring camera, and with the laser scans, we're able to, again, map the points onto the scene. That's why I showed you the report from the photogrammetry software that reported our error.
Sir, my question was just measurement, not your process.
Oh.
Did you measure the difference
I don't believe so.
between where the old camera was and where the new camera was?
No, it was angled slightly more to the right, though.
How would you know that if you were not retained on January 29th of 2022? How would you know where the original angles were?
Because when you look at the first camera, the one on January 22nd, it's here. The new one is slightly over to the right.
That's an eyeball approximation analysis. That's not a measurement, correct?
Well, I don't know that we actually measured it, but we accounted for it and corrected for it. But you can see, for example, what the original one shows, for example, to the left-hand side, compared to what the new one shows to the left-hand side, and it's angled more to the right.
Sir, you have experience with Ring cameras, correct?
I do.
And I think a lot of members of the public have experience with Ring cameras. You can move just the camera portion ever so slightly and change significantly the angle of the camera, can't you, what it captures? Just a small turn,
Potentially.
right? Even a millimeter turn can make a change. A 2 millimeter, a 1 inch can make a significant change with regard to what the camera captures, correct?
Could, sure.
So, did you measure whether the newer camera that was present on October 2nd, 2024 was installed to the left? And I'm talking measure. To the right, to the top, or the bottom relative to the camera that was there on January 29th of 2022?
So we solved for the camera
I'm
position.
asking if you measured, sir.
Oh, no, we didn't measure.
So let's talk about some other differences with regard to cameras and Ring cameras. Different Ring cameras can have different levels of distortion, correct?
Potentially.
Cameras, well, are you saying that all Ring cameras have the same level of distortion?
No, But again, they're mass produced, so you could have some that have the same exact distortion. You could have some that have different.
And you don't know the comparative distortion between what I'm just going to now refer to as the old Ring camera that was there January 29, 2022, and the camera that you saw on October 2024, which I'll refer to the new camera. You don't know the difference in the distortion between those cameras as you sit here today, do you?
So we know enough information that if the distortions had been different, our errors would have been too high. And so the fact that our errors are within acceptable, or what's called an RMS error, we know that the distortions are similar enough to give us accurate measurements.
Sir, that is speculation. That is not data. That is not a measurement. You didn't measure the distortion, sir, did you? If the cameras, you didn't have the old camera to do it.
We didn't, but we had images from the old camera. And then when we get images from the new camera and solve those camera properties and then overlay data from the old images to the new images with the point clouds, if that distortion is too great, we will have too high of errors in our project, which is why I showed the error report from the photogrammetry process to show that we have checked for that and documented that our errors are in acceptable range so that we have confidence in our results.
You do not have information from the manufacturer of Ring. You didn't present it, and you don't have it, as to what is the acceptable level of distortion for the analysis that you did, do you, sir?
The
Do you have that from Ring?
And I don't have it for Ring, but I
Thank
don't need
you.
it from Ring.
So now let's go to, if cameras have different levels of distortion, that would change the analysis in reconciling the difference between their angles. That's a pretty straightforward proposition, sir, wouldn't it?
So it depends on how much difference it is, but we have accounted for that.
With which model of the Ring camera was present at One Meadows on January 29, 2022? Which model?
I don't know. I'd have to go look through the data.
Do you believe you, I'm not going to take up the time to have you look, but do you really believe you've got the model of the Ring camera that was in existence on January 29th of 2022?
I don't know. I
You
need to
didn't
look through the
present it
report.
in your direct testimony, did you, sir?
I did not.
So do you have the model of the Ring camera that was present at One Meadows on October 2nd, 2024?
No.
So you don't have even the model for either one of them?
Nope, but we have videos from both of them and scans of the scene.
So now let's talk about another aspect of Ring cameras. They have mechanisms, as I was talking about earlier, that allow the user to adjust the camera angle, correct?
Correct.
And do you know whether there was a difference in the camera angle between the two cameras?
Yes, as we already discussed, there was a slight difference in the
But
angles.
you don't have a measurement of that, right, sir? I just
Correct.
Okay.
But we accounted for it.
So wouldn't a difference in models of Ring cameras be relevant at all to your analysis of trying to reconcile any differences between them?
So if you have video from both of them and you have laser scans with three-dimensional geometry of the scene, you can go in and it's called a reverse camera analysis and solve for the distortion properties. The scans give you the real-world dimensions. So once you know the real-world dimensions, you can then go in, you can go in and then solve for the camera lens properties based upon the real-world distortions. So for example, if there's a little bit of bending at the end, the laser scan data will show that, and you can correct for that knowing information about the laser scanner.
I'll
or
ask
the laser scan data.
I'm sorry, I thought you finished, sir. I'm going to ask the question again because it's a narrow question. Wouldn't knowing the difference in the models be relevant? That's all I'm asking. Wouldn't it be relevant to your analysis of reconciling the differences to them? Wouldn't
No.
it be relevant?
No.
So you think the different models are irrelevant to any process you occasioned at one? It's irrelevant.
So the analysis of the video itself is more important than the models?
I'm not asking if it's more important. I'm just asking, would it be relevant?
No, I don't believe it'd be relevant.
Now let's go to another aspect of the cameras. Are key parameters in a camera that the software needs to know focal length?
It is?
Is imaging size something that is an important parameter in a camera?
Yes,
Are sampling characteristics an important parameter in cameras?
can be.
Is the principal point, you understand that concept, sir? Is that an important parameter in a camera?
Define how you're using principal point.
Sure. A principal point of an image is the point where a camera's direct line of sight, called, as you may know, the optical axis, intersects the image plane. Does that
Gotcha,
sound
yes.
familiar? Mm-hmm. So isn't that the image's mathematical center, the principal point?
More or less, yes.
And for high accuracy photogrammetric work, it's important to know if the lens is mounted centered over the image sensor due to the small manufacturing variances, correct?
Could be important.
And if the principal point is the center of the image.
Okay.
That's relevant. So doesn't that affect the mathematical calculation of the light ray geometry?
It could.
So the variance in manufacturing between cameras is a known issue. Do you agree?
I do.
There's small manufacturing variances that affect one of the key components of the fundamental parameters of the camera, namely the principal point, right?
Correct.
Did you perform the camera calibration of the camera in place in October of 2024?
Yes, so within photogrammetry, we calibrated the photogrammetric analysis to the camera.
Did you address the principal point in that calibration? Do you have documentation that you addressed that important factor, the principal point?
So the checking of the RMS error in the software takes into account, sums up all the potential errors in the measurement, which would include that.
Okay. Sir, you know the importance of all of these topics because the output of all the work Aperture did at One Meadows, almost all of it, springs from that camera, correct?
It starts there.
Okay, it starts there. And if the starting point is wrong, then where you go from the starting point is going to be at least potentially wrong, correct?
Potentially.
Would you agree that Ring cameras have a swiveling mechanism so that the user can adjust the camera angle?
Some do.
Do you know whether the camera that was in existence on January 29, 2022 had a swiveling mechanism?
I believe it did.
Believe? Do you know?
I do not know for a fact, but
you-
those style of Ring cameras on the surveillance have adjustability that includes angle.
But you don't know whether the camera that was there, the specific camera on January 29, 2022, had a swiveling mechanism or not, correct?
Correct.
And do you know whether the camera that you saw in October of 2024 had a swiveling mechanism on it?
It did.
And where did you document the fact that it had a swiveling mechanism?
I think we have photos of the camera.
Did you document it in writing, and did you document the tolerance of the swiveling mechanism?
No.
Let's go to, and again, all of the camera, this camera that you used is the starting point for your laser scan and photogrammetry process, correct?
Correct.
All right. Let's go to another topic. On your direct testimony, as I recall, you stated essentially from various information that you lined up in the video, and we're talking about the lining up of the Lexus with the Traverse. And this is at One Meadows. And so, as I understand what you did, sir, is you took what are called point clouds, 3D images, created them for the Lexus. You took created 3D images, synonym point clouds, of the Traverse, and then you attempted to line them up to determine, among other things, whether they would align sufficient so that the Lexus could line up and potentially hit the Traverse such that the tail light of the Lexus could be broken. Was that at least part of your analysis?
That was part. There was more.
So, you showed a slide, a few slides, and with Your Honor's permission, what I'd like to do is to start with slide 90.
All right. Do you have any problem with Dr. Welcher keeping his printed copy that he was using?
I have no problem with the printed copy, Your Honor.
So, I'm sorry, what slide again?
90.
Your Honor, my printed copy tiny.
Okay.
Can I
Can
pull it
you
up?
see the,
Yes, yeah.
Does that slide that's part of your presentation depict a view from the top of the Lexus on the right and the Chevy Traverse on the left?
Correct?
And is that depicting contact between the two vehicles?
It is?
Now let's zero in a closer look, and that is a contact point, am I correct?
Correct? I mean, there's multiple points. There's more than one.
Multiple points, but it shows more clearly the contact
Correct.
between the two vehicles. Now if we could the next, and that is number 91, Mr. Wolk. So, Your Honor, 91. I think these are just going to go in order for a few, and I'll keep announcing them. So, this is 91, same vehicles, just a different viewpoint. Is that correct, Dr. Welcher?
Correct. This and the next
I
slide.
just want to stay
I know.
with this one. I
Hold
just
on a
asked the
second.
question, does it show the contact?
right. So go ahead and answer now.
This slide and all the other slides, we're trying to show the angle of contact, but because it's two-dimensional image, you're losing some perspective. For example, here you're seeing the chrome piece on Mr. O'Keefe's Chevrolet, which is on the right. You're seeing it obviously behind where the Lexus is. So we were trying to show it at a whole bunch of different angles to try and illustrate the degree of closeness or lack thereof.
Alrighty. So,
Thank you.
is it correct that on your direct examination, you said in sum and substance, we looked at the degree of overlap, and there's only about a 2 to 3 millimeters of overlap between the vehicles? Is that what you recall saying on direct?
That is correct.
And that you stated that supposed 2 to 3 millimeters of overlap was insufficient to cause the tail light of the Lexus to contact the rear of the Chevrolet. Do you recall saying that?
That's correct.
Now, I would like you to look at that. This is from your slide presentation. Is that not showing contact between the two vehicles?
Oh, it absolutely is not. What you're seeing is a portion of the vehicle that is behind the area. Keep in mind the angle, the Lexus is angled off to the left. So the area that you see here is actually, in this case, in front of where the taillight is. This is why we tried showing it from a whole bunch of different angles, because when you try and take a two-dimensional image and look at it, you see stuff in the background. So and again, this is why in the computer, we overlaid them, looked at the measurements, in the computer where you don't have this, we have the three-dimensional measurements, and it does not hit.
Where did you show in your slide presentation what you just said, that it doesn't show in overlap?
So
Where?
it shows a contact. It definitely contacted, I'm sorry, Mr. Reporter, down below here. it does not show a contact here. So to answer your question, all the next slides were our attempt to do that. So all the next slides is your answer.
We're going to go to those next slides. So just to be clear, you're saying that that depiction does not show any contact between the taillight of the Lexus and the Chevy Traverse.
So the upper taillight, just to be clear, because the lower taillight is much closer.
Well, it's not only much closer, it's in contact, isn't it, sir?
It's very close. It's probably within an inch of being in contact.
Oh, so you state that even the lower part of the taillight is not making contact?
So if, again, maybe there's a photo we could show or a scan. That is on the rear of the vehicle, and it contacts on the corner, which is just around, so maybe like an inch or so in front of it on the corner.
I'm just going with what you presented in your slide
Well,
presentation.
let's go to the next slides and then
Sir,
maybe
I
we'll see
will
it.
determine which slides we go
Okay.
to on my questioning.
I'm just hoping
So
to answer
now
your
let's
question.
go to, Mr. Wolf, the next slide
There we go.
in your presentation. My question is zeroing in. Are you saying that that slide does not show contact between the tail light of Ms. Reed's Lexus and any part of the Chevy Traverse?
Yeah, absolutely. It's exactly what it shows. You can see a little better here. Again, we tried all these different angles, which is why all these slides are in there. But you can see some of the geometry of the light. This structure, and again, remember I said the Chevy kind of curves in as it goes up a little bit?
Let's go to the next slide. 40. 40, yes, please. Is it working? 41, Your Honor.
That's Exhibit 41? No, I have a question, because that's not my slides.
So, Mr. Alessi, is this exhibit number 41, or is this from the PowerPoint? Because,
Slide 41? Slide.
okay.
Yes.
So I'm putting this up because I want to show an actual photograph of that tail light, and I would like you, sir, to focus on the quarter panel tail light in each. Do you see a jutting out of the quarter panel tail light in that photo? Do you see it jut out?
So I don't know if you and I are talking the same thing. There are little fins here.
Correct. Now, what I'd like to do is to go back to the depiction we were just looking at, and that depiction doesn't show the jutting out, does it?
No, it does. Those are actually more on the side of the vehicle. You can't see them in this image.
Correct. You
But-
can't see that.
Hold on a second, I wasn't finished. But
Sir.
they are 100% there. We actually did special hand scans with a hand scanner of the taillight to put it back on to the vehicle.
You say they're 100% there, but you can't see it in that depiction, can you? The jutting out, that you could see in the two-dimensional one we just saw. You can't see it.
I can't see who's behind that wall because it's being blocked by something. I can't see on the side of the taillight because it's on the side I can't see. It's being blocked.
Sir, my question is simple. You cannot see the jutting out of the tail light in this depiction, can you?
Correct.
Okay, now let's go on to the next question in this topic. You could have easily solved what you consider to be the issues you had with trying to show it lining up, couldn't you, sir? You had an easy solution for that.
I took the best solution. I'm not sure what
You
you're
had
referring to.
3D images correct?
I did.
You could have shown and measured 3D images to get almost the exact contact point and almost the exact dimensions if you had just used the 3D images that you had available to you. Isn't that correct?
That's exactly what we did. When I went through the video analysis, I showed you how we overlaid the point clouds, the 3D scans, on top of each vehicle. So we took the, I'm sorry, we took
Sir,
the vehicles.
please don't interrupt.
Hold on.
Your
Hold
Honor,
on.
he keeps referencing my hand and saying I'm doing something when I'm not, and I think that's distracting to the jury.
So-
I'm not interrupting
Hold
him.
hold on. Let the witness answer the
I
question.
am. I'm just holding my hand like this, Your Honor. He keeps
Holy
saying that I'm
shit.
doing
Mr.
something.
Lessie, please.
All right.
Go ahead, finish the answer, Dr. Welcher.
Again, in the photogrammetric analysis, I showed the video, I showed how we overlaid the point cloud
Doing something
on
with
top
my
of the
hand.
video. That proves that the way we solved it, correct camera characteristics, matches, otherwise that would be distorted. We overlaid the scans of the Lexus into the photogrammetric analysis. We overlaid the scans of the scene into the photogrammetric analysis. We overlaid all that stuff into the analysis. We did exactly what you're suggesting.
You could have easily addressed this issue by the following. If you really believe there was no contact or not sufficient contact, you could have produced a graphic that shows a gap between the two vehicles. A graphic, couldn't you? That's not a graphic.
What is that?
Sir, I get to ask the questions, and you are to answer them subject to the judge's ruling. So my question is, couldn't you
good
have
times.
created a graphic that
That's-
would have better shown the issue that you are creating or talking about today? That's my question. Couldn't you have created a graphic?
We did. We created a whole bunch of graphics.
You called what we just saw a graphic?
Yes.
Well, if there's a gap, why isn't there then something that shows a clear gap?
Because when you have the angulation of the vehicles, you have perspective. When you're looking at it, even if you do a top down, you see everything projected onto a single flat plane. So you can't tell the height of things. So when you see things in this dimension, you can't necessarily see depth of things. So you lose in two-dimensional images, you lose one dimension depending on which way you're looking. That's why I showed it from all these different angles to try and show exactly what you're saying. We had graphics to do that.
3D images allow you to show perspectives for 360 degrees, correct? Is that correct?
That is correct.
So, none of what you presented in your slideshow shows the contact points from 360 degrees, does it?
I don't understand your question. Are you asking if I showed it at every single, I went through 360 slides that showed it at every single degree?
Sir, let's move on. I think I've made the point.
So I'm going to strike the comment,
Okay.
Mr. Leslie.
Dr. Welcher, let's go to the next topic. And keep with these two depictions. Are these two images point clouds or 3D images? Are these two?
Those are one and the same thing. They're yes.
I would use them as synonym. Which term of the two do you want to use? Point cloud or 3D images?
Both are fine. It's a 3D image composed of points, which
Okay, so let's just call them 3D images, so we
Okay.
can do this more quickly. The Lexus and the Chevy Traverse that are depicted there are both 3D images of those vehicles, correct?
correct.
And Aperture created the 3D images, correct?
Correct.
Sir, did you do these scans and did you personally create these images?
No, one of the assistants at Aperture did.
So you're speaking about what somebody else did at Aperture, correct?
They were doing it at my direction. And for example, the Lexus scan, I showed the photographs. You can see the gentleman that works at Aperture, Mike Morelli. was scanning them for me while I was doing the rest of the inspection. And then the hand scanning of the rear tail light was done by another engineer. I was out there with him doing it, taking measurements. And then same thing with the Chevy Traverse.
My question is, you didn't do the creation of these 3D images, did you?
The individual images, no.
All right, so let's go to these individual images. These are 3D images, is that your testimony?
Yes.
Let's look at the taillight.
Okay.
That's not a 3D image, that's a Photoshop, isn't it?
Nope.
Oh, so it's your testimony that that taillight is a 3D image?
That absolutely is a 3D image. The way you can tell is when you get up near the chrome, because lasers don't like shiny objects, you start to get a scatter. So see all these dots here? If that was a photo, you wouldn't have these dots.
Let's go to the Chevy Traverse. Let's, Mr. Woke, zero in on the content, yeah. There's grain on that taillight, in the taillight. That's a 3D image of a taillight, isn't it, sir?
They're both 3D images.
Well, I just want to stay with one. That taillight is a 3D image, and one of the ways you can tell is because it's got all that grainy material on it, correct?
Correct.
Now let's go back, Mr. Woke, to the Lexus. Let's now go to the bumper.
But do you want me to explain the difference?
No,
Okay.
thank you. I would like to go to the bumper. Do you see any the predominance of any grainy image?
Wait a second. Shiny lasers and snow that you can track a cat with? How do these two pieces of testimony go together? Oh my God, it's all coming together. The cat's in the show and the snow and the shiny laser. It's happening, people.
Image on the bumper.
There's a little bit. So for example, when you get near edges, it has a hard time with edges.
I'm
So
sorry,
you-
the bumper cover.
Right.
See the bumper cover up above?
This whole thing is the bumper cover. That's the step pad. That's the rear body panel or the rear deck lid.
I'm talking about the step pad, sir? Just the step pad of the bumper?
Are you asking about just from here to here?
Correct. The bumper step
Can we
pad.
zoom in on it?
Pardon me?
Can we zoom in on it?
Sure. Do you see any?
Yeah, I see graininess.
Let's go over to...
Right in here. You can see it all through here. You see it through here.
Well, I'm talking about the step pad, not the entire bumper. I'm just talking about the step pad.
Right. So you're zooming in on the bumper.
Right.
The step pad is this structure up here.
We're going to move up. It just takes a while. So your testimony is that is a...
Can you zoom in more?
That's
Right.
You would like it zoomed in?
Yes, sir.
Sure.
There's got to be a sound effect for this. Hold on. I got to find the sound effect for this. There's got to be a
Your
sound effect of a store
testimony
for
is
this
that
one.
that is
Hold
a
on.
3D image, not a Photoshop step.
Where is it? Okay, this is going to
Bumper
take a second
cover. Is
because
that
I'm
correct?
not running 100%.
So we have mapped
Let's see.
the color over the 3D scans. We used
where
two
is
separate scanners. If you recall,
This is a lot of effort
when I
for a
got out
joke.
to Miss Reed's vehicle, that taillight was gone. So we had to replace the taillight.
Talking about the bumper cover, not the tail light.
Okay, I'm explaining the process.
I'm just asking about the bumper cover, not the process.
So focus your answer on the bumper.
That is a laser scan.
I think this is it.
The sun is
Okay,
a
so
deadly
your
laser.
testimony
3D model.
is
There we go. That was worth
The
it.
step part of the bumper cover is a 3D image from a laser scan, and it's not a Photoshop. That's your testimony.
Absolutely.
And you didn't perform the work for the 3D that you claim the bumper step up is. You didn't do that work to produce that depiction, did you, sir? Somebody
So-
else in your firm did it.
So this is all done at my direction. The engineers that work for me, so I'm telling them what to do. I'm not the one punching the keys.
That's
I'm
my
saying,
question.
I need you to do this, and this. Use the hand scanner, go scan the light. I need to put this back in because it was missing when we got to it. So no, I'm not punch in the keys.
Okay, so
Okay. Come on over, please.
Sidebar.
The sun is a deadly laser.
Yeah. We're having fun. It's all fun. Man. Spinny fan. Spinny fan. Yeah, Spinny fan. We're in some other world now. We're in Alice in Wonderland territory or something, Spinny fan. I don't know, man. I don't know. Spinny fan has a better chance of going to space. I believe in Spinny fan's spacefaring journeys. Although Spinny fan might have a problem as it, gets higher up in the atmosphere because less air. So I guess centrifugal force will still allow it to move despite the lack of air, though. So that's fine. It doesn't need air to propel itself. The centrifugal force will allow it to propel itself through space. Excellent. That's good news. Does the Spinny fan shoot out lasers? Not to the best of my knowledge, but we could put some lasers on it or some strobe lights or something. That'd be cool. And then it could send out messages. That'd be good. Although we don't know what Spinny fan gets up to when it goes to the club. Who knows? Spinny fan likes EDM music confirmed.
with regard to, no, we don't need him back up, Mr. Wolf. Isn't it correct that 3D images allow for proper and most accurate measurements as opposed to 2D images? Is that a correct general statement?
I mean, generally, yeah.
Okay, that's my question. So let's go to the next topic. Let's talk about hydraulics on the Lexus SUV. What type of hydraulic system does the Lexus SUV have?
So it has a mechanism, I believe it's actually pneumatic, it's air-based system that raises it up and down.
Do you know what the name of that system is, sir?
No, not off the top of my head.
Do you know how it works
I do.
specifically?
Well, I mean, I know generally that there's a button on the interior where you can raise and lower the ride height.
And is that the extent of your knowledge of that system on the Lexus?
No, again, I know when you park it, it'll drop down the ride height. When you adjust it for different roadway conditions, it'll change the ride height.
Do you know what the height tolerances are? In other words, the lowest to the highest?
I believe it's around 1.25 inches. At one point in time, I measured it. I don't remember off the top of my head.
So you believe it's 1.25 inches up and 1.25 inches down? How do you apply the 1.25 inches?
I recall the total being like 1.25 inches, but I measured it at one point in time. I just don't remember off the top of my head.
Would you be surprised to hear that the tolerance is 5 inches on that vehicle?
I would be surprised. I don't recall it being that much, but I would need to double check.
Assume that the manual as well as other informations support that the tolerance is 5 inches and that specifically the vehicle can be raised 3 inches high and it can be lowered 2 inches. That's
3 plus
the
2 is in
basis for
fact
the
5. Yeah, I mean,
What was the suspension height of Miss Reed's Lexus that you used for your accident reconstruction analysis out front at 34 Fairview between 12 a.m. and 1 a.m. on January 29, 2022 to determine whether it was possible for the spoiler on the back of the Lexus to make contact with the eye of Mr. O'Keefe? If it was even possible, what did you use for a measurement of the suspension?
Matched the measurements from when the vehicle was tested, I believe on February 1st at the Canton Police Department.
What match did you make?
So we aligned the bottom of the taillight, actually the sheet metal right below the taillight. So we adjusted the height of the Lexus to match that.
Did you in any place document what level the Lexus was at the time of any testing, meaning the suspension? Did you document at all?
Yes.
Where?
Slide 107.
Can we have slide 107, Mr. Wolf?
And then if you could zoom in on the lower photograph, the gentleman with the blue shirt. Zoom in a little more, please. So if I may, we matched the bottom of the sheet metal here to photographs when it was at the Canton Police Department.
Sir, my question is, where did you document whether the suspension was at 0, whether it was +3 or -2? Where did you document that?
Right here.
And what are the numbers of the documentation of that?
I don't know. We were matching the photo.
I documented it. What are they? I don't know. Excellent. Very good.
So I don't care what the numbers are. I care that the height is the same.
Okay.
You don't care what the number is. Also excellent. The engineer does not care what the number is. Fun. Excellent. Very good.
So I just heard you say, if I heard correctly, you don't care what the suspension is at. Is that your testimony?
No, I don't care what the suspension number is as long as the heights match.
I understand. I understand.
Uh-huh.
So what was the suspension height of Miss Reed's Lexus at 5:07 a.m. on January 29th,
reasonable question.
2022 while at One Meadows
You have no idea.
and colliding with the Chevy Traverse? What was the suspension height then?
We assumed it was the same as when it was at the Canton Police Department.
Exactly.
Yeah, you have no idea.
assumed,
You have
but
no
there's
idea.
no measurement like was just on that depiction. There was no note that said, okay, we're doing this very important and inches sensitive measurements to see whether the
Yeah,
tail-
and I mean, to Leslie's credit, he himself testified quite vociferously that, the smallest changes would change things, right? So it matters. It's, an inch might not matter depending on what we're talking about. Maybe it doesn't matter, but he said it mattered because he said that, the exact body position, the exact way that he's standing, whether his foot's off the ground or not, all those things matter. So, the exact height so he thinks it matters because he thinks the smallest changes in the input could have potentially fairly radical changes in the output. It's very input sensitive. And now he's like, it doesn't matter. I didn't care. That doesn't really work in the same universe, sir. Those thoughts don't go together, sir.
light on the Lexus makes contact with the Traverse, but there's no measurement and no documentation of what the suspension height was at One Meadows, correct?
So we took the closest measurement in time to the One Meadows event, which is when it was at the Canton Police Department. That was the best information we had.
Yeah,
Well,
but you don't know. You
That
have no idea.
information isn't very good because the vehicle had to go from Canton to One Meadows, and when the vehicle drives, the way the suspension system works, it's automatic. When you go above 20 miles an hour,
Yeah.
the suspension comes up, and
The very act of driving the car onto the tow truck might have changed the height in a way that, again, from his own point of view, is material. Right? He's the one who said that it's incredibly sensitive. Exactly how he's standing, exactly how the thing is. All these things are incredible. The smallest change could lead to potentially radically different results. So the very act of driving the SUV onto the tow truck could have changed the suspension and therefore changes the inputs, and therefore could potentially somewhat radically change the outputs. Yeah, that's a problem, sir, Mr. Engineer.
And when you turn off the vehicle, it goes down so you can get out easier. So it would be improper to assume that the suspension at One Meadows would be the same at another location.
That's the only, sorry.
Was there objection? Yeah. Go ahead and answer, please.
That's the extent of the information we had. We had it when it was at the Canton Police Department.
That's-
We matched that height.
Sorry, sir. I understand.
But actually, you brought up a good point. It's going so slow when it's backing up that it wouldn't raise up. So the static position when it's backing up would be.
You know that? You know that the suspension would, that the suspension wouldn't change on the Lexus? How do you know that? It might be true. I don't know that. Maybe the Lexus would not change. How do you know that? Do you know that because of testing? Do you know that because it's in a manual somewhere? How do you know that the Lexus wouldn't change? How do you know that? When it's so input sensitive. How do you know that, sir? Where are you getting this exciting information from? Please tell me more.
Be the static position.
But it wouldn't be going in backup from the Canton Police Department to One Meadows. It wouldn't be going back up when it's going in other locations, sir, right? It would be driving.
And as Aston King points out in chat quite correctly, it goes lower according to him when it is put in park. He said that, remember? Yeah. Good point, Aston. Yeah, when he said that when it goes into park, it lowers itself, so it makes it get outer. So when they drove the car into the Sally Port, they then put it in park, didn't they? Presumably. And so then didn't it lower itself so it wasn't accurate anymore? Or at least it wasn't the same? And then inputs yeah, good point. Yep, that's a thing. Good points. These are all good points. Yep. The stupid is real. The stupid is real. For what he says is a very input sensitive equation.
Forward. It had to get from point A to point B.
Right, but as you pointed out, when you turn it off, it drops down, and then you turn it on, and then once you go above 20, as you indicated, it goes up. But when she's backing up, she never goes more than a couple miles an hour. So it's going to be at the same position as when you start, which is approximately the same position when it's off at the Canton Police Department a couple days later.
Mm-hmm. Do you know whether the suspension system locks?
It's a good question.
When there is testing of the infotainment system?
Whether the suspensions, I don't know.
Okay. Let's go on to the next topic. You're aware of the vehicle control, excuse me, Your Honor. Thank you, Your Honor. I'm changing topics to go back now to Fairview, 34 Fairview. You don't know what the suspension ride height at 34 Fairview was on January 29th of 2022, do you?
Correct.
So therefore, if you don't know what the suspension height was, because of course you weren't there on January 29, 2022. There's no measuring stick, as you say, you assert that you would have accounted for it in your methodology. So you don't have the suspension height for that key day, do you, sir?
I only have it 2 days later.
All right. So when you talk about key measurements, such as the spoiler on the top of the Lexus And the inches that are important as to whether things such as is there a contact with the front eye, you don't have some data that would be relevant to that calculation, the sum data being the suspension height of the Lexus at that time, do you?
So we have some data. We have photos of the vehicle 2 days later. We don't know the exact height outside because, as you alluded to, we don't have a measurement on January 29th of it, but we do have it 2 days later. That's the source of the measurement.
You don't have the suspension height or the setting of the suspension of the Lexus that existed on January 29th, 2022, do you?
Correct.
Now let's go on to another topic.
Nice way to drop the mic on that one. Nice way to close out the question. Good job.
Within the 34 Fairview on January 29th of 2022, I'm not going to go over them, but you asserted various measurements, height, width, with regard to the Lexus, correct? It wasn't just for the spoiler at the top, correct?
Correct.
And for all those other measurements that you talked about, you did not have the suspension height and the suspension setting of the hydraulic system of the Lexus on January 29th, 2022, did you?
So the hydraulic's only going to affect the vertical dimensions. It doesn't change anything left to right. It doesn't change anything down the side of the car.
Understood. But for the measurements that are affected by vertical, you didn't have the suspension height of the Lexus system on January 29, 2022.
Again, I only know what it is 2 days later.
So now let's go on to vehicle control history. Sir, you understand what I mean by vehicle control history of
Do? This is
VCH?
text stream information?
Are you aware of what is called the Bosch crash data retrieval system in Lexus vehicles?
Of course, we showed it on my slides.
And the Bosch crash data retrieval system in Lexus vehicles is sometimes referred to as the black box.
No, you're mixing up two things. So the Bosch is like the tools.
It's a question, sir.
So, can you answer that with a yes or no?
Is the Bosch crash data retrieval system the black box on Lexus vehicles? I just wanted to repeat it so we can.
I didn't hear what the objection. You objected?
I'd like him to be able to finish his answers.
Yeah. So the question was just asked. Can you answer that question?
No, it doesn't make sense.
Okay, next question, Mr. Wilson.
I'm going to ask the question, sir. The Bosch crash data retrieval system in Lexus vehicles, you're familiar with that? Are you familiar with it?
There is no such thing in the Lexus.
A Lexus does not have a Bosch crash data retrieval system?
No.
Have you read the report of Trooper Paul,
Yes.
the May 2023? Does that report not use the exact words Bosch? Let me ask you this. Do you recall?
Sustained. The
Okay.
objection sustained.
Let's go to the VCH system in Lexuses. Is the VCH system intended by Lexus as a diagnostic tool for their technicians, Lexus technicians, to assist in vehicle repair and maintenance? Is that what that is created for?
That's their stated purpose.
Right. And is a synonym for VCH TechStream?
Sort of. TechStream, similar, like Bosch is the hardware and software to access the black box data. TechStream is the software to access, for example, the pre-collision system, the PCS system, and the VCH, which is the vehicle control history. So TechStream which does a lot of other stuff, but does access that information.
You just mentioned Bosch, didn't you, sir?
So Bosch is not in the Lexus. You use Bosch stuff sold by Bosch, Bosch software and hardware, and you walk up to the Lexus with all the Bosch stuff and plug it in and download the event data recorder, the EDR, the black box. That was my problem. There is no
Understood.
Bosch stuff in the Lexus.
I understand, sir. That was going to be the question that I was trying to get to, but you've explained it, so I don't have to answer the question. Let's go to the VCH database. That you say the stated purpose is to assist technicians at Lexus in vehicle repair and maintenance.
So I didn't say that was a stated purpose. I'm saying that's what Lexus or Toyota says is a stated purpose. It's being used in litigation all the time. All I know is that's what Lexus and Toyota says. But again, it came about right when we started seeing all the sudden accelerations in the Toyota vehicles.
So my question is the VCH database specific to Toyota and Lexus vehicles?
So it's not a database, it's software.
Is the software specific to Lexus and Toyota, the VCH?
Those particular acronyms are, yes.
Want to move to another topic, and we are almost finished. We have just 2 more topics, sir.
Cross-examination's almost over? That's sad.
How common were VCH events when Miss Reed owned the Lexus?
In 2022,
Do you know the ownership period of Miss Reed with respect to the Lexus? Do you know how long she owned it?
I have that documentation, I don't know off the top of my head.
Do you have an approximate?
No, I mean, it was a 2021 vehicle. Our accident's January 29, 2022. But I did get that information.
Do you know how many VCH events were associated with the Lexus of Miss Reed?
I did not count them, no. I have them all.
Do you
I was
have-
only focused on the ones around our time period.
Exactly. But do you have the number of events? Do you know how many there were?
I could get it for you.
How long would it take, sir?
3 minutes?
Why don't we come back to it?
Okay.
And we'll see if it's...
How about I start this so that we don't have to wait for it to boot up? And then when we come back to it, it's ready to go. You
As
okay
long
with
as
that?
that's all you're looking at, sir.
Yep.
Thank you. And then pick your head up, please, so I can finish these 2
Please,
topics.
go ahead.
So how often were VCH events recorded on the Lexus before January 29th of 2022?
Man, I have to pull this data up.
Fair
to
enough, fair enough.
answer that
I
question.
assume that's going to be in what you're also pulling up.
That's the goal here.
Would the number be about 15, 1-5? Does that sound right to you?
Let's see, 1, 2. There's 18.
18. So there were your records show that there were 18 VCH events recorded on Miss Reed's Lexus, correct?
Before the subject one.
Right. Did you conclude that any of those events, other than the 1162-2, were a collision?
No.
Now let's go to reverse recorded events. Can you tell how many of those 18 events were reverse recorded events? And you know what I mean by reverse recorded events?
Yes.
The vehicle going in reverse?
Correct.
How many of those events were the vehicle going in reverse?
And this is before.
4. Other than...
He asked
No,
you,
I said
is this before?
Yes, I'm sorry.
Oh, I would have to pull up the PCS file.
Could you start that and I can continue on with the questioning?
I got to, So the PCS file is I have a second laptop that
Here's
has
what I'm going to
texturing.
do. That's not important for me to keep going and get through it,
Okay.
so let's just stay on the events, okay? Only one
It's too early
of
for
all
this.
of those events, those 18,
It's way too early for this.
are you concluding that there was a collision associated with them, correct? Just one.
No, all those 18 are before. The collision's number 19.
No, I'm saying, I understand what you're saying, but for all the other events that are recorded, you're not, other than the January 29, 1162-2, you're not concluding that any of those were collisions, correct?
I didn't look at them. They were so far mileage away from everything.
But you're not concluding, even though they were so far away and you didn't look at them, you don't conclude from the information you have that any of them were a collision, correct?
Sustained.
Let's go to 5:07 a.m. on January 29th, 2022 at One Meadows, the home of Mr. O'Keefe.
Okay?
There was a collision between Ms. Reed's 6,000-pound Lexus and Mr. O'Keefe's approximately 4,500 Chevy Traverse. That's undisputed, correct? They collided, they made contact.
They touched.
Right. But the actual collision at One Meadows did not register the recording of an event on the Lexus VCH system, did it?
Correct. It's too minor.
So, however, you want this jury, sir, to conclude that the glancing blow that you contend occurred at 34 Fairview Road by the same 6,000-pound Lexus in contact with a mere 216-pound man did register an event on the Lexus, correct?
No. The impact didn't register the event. As I pointed out, the trigger was from when the accelerator pedal went to 30%. The tech stream does not register crashes at all. It registers excessive acceleration, excessive steering, excessive braking, things like that, things that would be part of the maintenance system. So the tech stream will never register an event, even if you hit a wall at 100 miles an hour necessarily. I mean, it'll cause fault codes and things like that, but that's not what it does. The trigger here was transitioning into reverse and then gunning the accelerator pedal in reverse. And so when it went from 30 up to 74% throttle, once it went over 30 in that transition, that's what triggered the tech stream. It had nothing to do with, and that's why I'm telling you, I don't know when in that event the impact occurred, because the tech stream doesn't tell you that.
Thank you. That
You're
is
welcome.
exactly my point. The tech stream information doesn't tell you when a collision occurs, does it?
Correct.
That's all the questions I have at this time, Your Honor.
All right, why don't we take our morning recess, Charles?
All right. This is good stuff. All right. In chat, for those of you who are not paying attention, apparently we have an insurance agent who owns a Lexus. And so I asked, what is the coverage relating to this? And he said, it should be covered under my standard policy because there's no space exclusion. Then someone in chat pointed out quite correctly that if my Lexus randomly wound up in space, the insurance company would probably say it's an act of God and not cover it. So I was like, yeah, I don't feel sufficiently secure on my language. I'm going to need a special space bond or rider. Now, I don't actually own a Lexus. I own an Infinity. I don't think that would actually change the equation here because how could it possibly? But our insurance agent friend says it might be $12 for this policy. I'll tell you what, my friend, if you can get me a written policy, that says if my car winds up in space, that they will pay for my car and it's $12, I will pay you $12 just for the meme at this point. It is totally worth it. I will do it. I will give you information about my car. so that I can get an insurance policy that says if my Infinity winds up in space or the moon, which I suppose is the same thing, outside of the Earth. Let's just yeah, if it winds up in space or other celestial body, that the insurance company will guarantee to pay for my car. It's $12. I will give you $12 just for the meme so I can have it. This is the best thing I've ever done. This is worth $12 in my day. It is worth it for the meme. And other people might do it for the meme too. Who knew meme insurance could be a thing? There's a whole new market possibility. I want insurance basically for things that are impossible. This is really good for the insurance company because it's free money for you because it's impossible. So, that's really good. And it's good for me for the meme. So we all win. You guarantee an event that is basically impossible and I get some meme insurance. Meme insurance is great. Who knew there was a market potential for this? But there apparently is. Exciting and fun. Yeah, I've got a 2009 Infiniti FX35 if you want to put that into the equation. Estimated value is probably something on the order of $7,000. It's got probably 150,000 miles, give or take. Estimated value something in the $6.5, maybe $7,000 range, something like that. You give me insurance, give me a declared policy for that one. That'd be good. I'd approach my current insurance company about it, but I think they declare me insane. So I don't want to approach them. I want a separate policy. Get from whomever. That'd be good. Trouble benefits. Yeah, I want triple. Actually, at this point, they should just give me anything because again, impossible. So yeah. If your car winds up in space, we will pay treble. We will pay treble rate replacement cost. Yeah, good times. All right. Yeah. A marine rider? I mean, technically space is maritime law, so yeah, probably. Yeah, that's good. Yeah, yeah. They won't cover previous dents already on it. Yeah, yeah. It's in good condition. I mean, it's definitely got a few scratches on it. It's not in perfect condition, but it's actually in pretty good condition for a 2009 car, if I do say so myself. It has had some repair work already done on it, but the car looks good. The repair work was done by an Infinity certified repair shop, so there's that. But it's a good car. I like my car very much. I like the way it looks. I like the way it drives. The door mirror motor is broken, so it just is continuously running all the time, so that's a little annoying. I could pull the fuse. I might do it. Yeah, I should probably just pull the fuse of the door mirror so that way it would stop running all the time. It doesn't it's not causing a problem because it's already broken, so it doesn't really matter. It's just kind of annoying and slightly loud. $12 for meme insurance? Yeah. I'm paying $12 for the meme. That's basically what we're doing. Yeah, that's what's happening. Just slicing a toggle switch? Well, I suppose I could do that, but that feels like a lot of effort and also why? I don't need the door mirrors to work. The only reason to power them is so that I can adjust them, but as long as it's only me driving, it should be fine. So, I might pull the fuse. It's just annoying. Thank you, by the way, for the 642 of you who are currently here. We do have a potential for a limited edition item, which I haven't yet approved, I don't think, unless one of my staff members approved it without telling me. Did they approve it? Is it for sale? It looks like it's for sale. Okay, so I guess they approved it. But we do have a limited edition item. The Unexpected Black Hole Limited Edition, now featuring a car falling into the black hole. So if you're interested in that, that's available. And now we've got redirect from Brennan. I'm sure this is going to be great. All right, Brennan, redirect this bullshit.
Good afternoon.
Good afternoon, Mr. Brandon.
You were asked some questions.
Actually, it's morning, but yes.
You were asked some questions about the ring video from Meadows, which was John O'Keefe's home. And you were asked whether you're aware if the cameras had changed over time.
Correct.
The fact that the camera was replaced, does that any way affect your opinion to a reasonable degree of engineering certainty about your conclusions relative to that touching between the cars?
Absolutely not. It would have shown up as increased error when we overlaid the point clouds onto the photos or the point clouds onto the video. If it was an error, it would have showed an error.
Do you have any concern whatsoever that any of the information from the scan is in any way tainted, compromised, or inadequate?
That would be very hard to do. You literally press a button and stand there and watch it, and the laser does its thing. So I have absolutely no reason to disbelieve it. Additionally, again, if it was messed up, once you laid it over on top of the photograph, it would show the difference. So no, the data's fine.
Is there any evidence whatsoever that you've seen that any parts of your presentation were photoshopped?
No.
You were asked questions about the suspension of the motor vehicle of the defendant's Lexus. Do you have any information that the suspension at any point was changed?
No.
Yesterday you were asked a number of questions about formulas. You took out your calculator and you were asked about different variables. Were those variables hypotheticals or were they related to this specific case?
So they seemed hypothetical. Again, you have to be careful when you're talking about failure forces on biomechanical things. For example, if you impact the hand with a, say, 1-inch narrow metal bar, that's a lot different than if you have a broad, say, plastic taillight or rear body panel. So when you have distributed loads, you can take much more. I told you guys about sitting on the bed, like how much you sink in. That's an example of spreading your load out. When you spread the load out, you don't sink in as much. So same thing with, forces on your body. If you take this pencil, I don't have to press very hard for it to pull in. But if I spread it out, I have to press much harder. So you have to look at the distribution of the load when you're talking about the failure. So when you look at the failure loads, it depends on what you're doing it with. If I hit you with a 5-pound 2x4 or a 5-pound pillow, they're both 5 pounds, but you'd much rather get hit by the pillow than the 2x4.
Is it? Are they both 5 pounds?
When you were asked questions about communications, when you would have communications with the Norfolk County District Attorney's Office, did you ever use encrypted apps to secretly hide your communications? Apps like Signal?
No, I don't have any of those.
So the form of the question, ask it differently.
One moment,
When you were-
please.
I've got a question for you. What's heavier, a kilogram of steel or a kilogram of feathers? That's right, it's a kilogram of steel, because steel is heavier than feathers. What do you mean?
They're both a kilogram.
But steel's heavier than feathers.
I know, but they're both a kilogram.
What? It doesn't prove anything. Steel's heavier than feathers.
I know, but look, they're both a kilogram, right? So they're the same.
I wouldn't want to look at the size of this. That's cheating.
No, they're the same
No,
weight.
it's a kilogram.
But steel's heavier than feathers. Paul going to tell them?
They're right.
They're both a kilogram. Oh, no, you know. What is it you don't get? I'm joking.
Are you alright?
I don't get it.
It's all right.
Don't worry about it. Get it.
Communicating with members
thank
of
you
the
for that
Norfolk
humor
County
break,
District Attorney's
everyone.
Office, did you ever use encrypted apps like Signal to communicate?
Objection, scope, Your Honor.
I'm going to allow it.
No, I mean, I don't even know what that is.
Would you ever use an encrypted app so those communications couldn't be tracked?
No.
Would you ever have any reason as a professional for doing that?
Objection, Your Honor.
Sustained.
You were asked about confirmation bias. You remember those questions?
I do?
Could I have slide 33 of your PowerPoint, please?
I'm sorry, what number?
Slide 33.
Give me a second. $33.
You could zoom that in, please. A little larger so we can see it.
I cannot do it with one monitor.
You can't do it any closer than that?
Not since I took down, oh, hold on. Here we go. Which part do you want me to zoom in?
Ms. Gilman can zoom in for you.
Sorry? Which part?
Ms. Gilman's going to do it for you.
Oh, there you go. Perfect.
If you could zoom in, please. Okay. On shift position signal, going forward, then neutral and reverse, does that data suffer from confirmation bias?
No, that's strictly electronic data.
When we look over at the vehicle speed, can we go to the left a little bit? Down. Vehicle speed ending at 2361 miles per hour. Does that suffer from confirmation bias?
No, again, these are direct readings from the vehicle. Again, that speed on this here, you have to correct for the slippage, which I do later on in the slide, but that is a direct reading from what the speedometer is seeing.
Acceleration at the end of that 10-second window, 74%. Does that suffer from confirmation bias?
No, that's a direct reading of a sensor. That's objective information.
I have no further questions. Thank you.
Wow.
Thank God.
Anything, Mr. Lessie?
Your Honor.
Yeah, Your Honor.
I'm
Thank you.
disappointed. I thought we were going to have this guy
Dr.
all day.
Welcher, you were just asked questions about slide 33, which is the slide about text stream data. You acknowledge that text stream data, what you have called a trigger, like was on that slide, does not tell you if a collision even occurred, correct?
Correct.
With regard to the topic of confirmation bias that you were just asked about in slide 33, am I correct that all of the questions that Attorney Brennan just asked you were about data on that slide, correct? All that's on that slide is data, correct?
How do you ask me more questions than just this slide?
But were the questions just about data?
On this slide, it was just about data.
Correct. But confirmation bias is really aimed at opinions and conclusions and alternative hypotheses. Isn't that what confirmation bias gets at?
So, generally, yes. Again, I started this case with
It was
the
just a question.
hypothesis.
Go ahead, sir. Go ahead.
With the hypothesis that the Lexus didn't contact Mr. O'Keefe. And so I start what's called the null hypothesis, that this didn't happen. And then I look at evidence to either include or exclude the null hypothesis. So theoretically, my confirmational bias starts with a bias that it didn't happen.
Can you point to one?
I don't believe that. I don't believe that, in fact, that he started with a null hypothesis. Yeah, I don't believe that, in fact, that no. I don't find that credible. No. 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 Yeah.
That shows that you analyzed whether there was no contact between the Lexus and Mr. O'Keefe. Can you point to one document? Was there one document on your slide presentation, for example, that analyzed the null hypothesis, as you call it, there being no contact at all? Was there any slide in your direct testimony?
So remember what I said, we start with hypothesis, we get more data, we whittle down our hypothesis to the final answer. I mean, I had 130 slides. I suspect I bored some of these people to death already. So I didn't include everything. There's thousands of photographs in here. There was a bunch of testing I did with the Lexus about backing, pedestrian detection that, you know, removed certain hypotheses. So if I was able to eliminate a hypothesis, I didn't present it here.
Sir, my question is not about your...
All the slides show that, to answer your question.
Sir, my question is there any slide that says alternative hypothesis to whatever the label is, whatever the term, it says no contact between the Lexus vehicle and Mr. O'Keefe? Is there any document that you presented to the jury that shows that?
Any document where those words are written on it?
Correct.
No.
And to work through hypotheses, different ones, and to see whether there's confirmation bias, have you heard of scientists refer that as showing your math, so to speak, in working through hypotheses, documenting each hypothesis and how and why you rejected them? Have you heard of that term in the scientific world, show your math with confirmation biases and alternative hypotheses? Just a question. Have you heard the idiom, the phrase, show your math?
Your question is, have I ever heard show your math, period?
Associated with the application of various hypotheses to avoid confirmation bias. Have you heard of that term used in that conjunction?
Not really in that
Okay.
context. It's probably, I understand where you're going with it.
Thank you, sir.
You're welcome.
No further questions.
Dr. Welcher, you were all set.
Yay.
Give me a minute to pack up and I will.
Oh, Judge Bev looks so happy. Oh, she looks so happy. Let's smile. Oh, how nice for her.
Out of here. Oh, I am plugged in, yes, thank you.
Excuse me? Yes, you can put your
Thank you.
Yeah, you better start packing. You better start packing. Burgess needs to pack. You need to pack. Lots of packing. Aperture is probably already helping you with the packing as we speak. They're already ahead of you on helping with the packing. All packed.
I'll do this out there. May I step down? Your Honor?
Yes, you can. Thank
Pleasure
you
to
very
meet
much.
you.
Mr. Brennan?
Is there another witness?
Commonwealth moves to introduce and play clip 26.
Okay. Maybe some final clips to round things out. Let's watch clip 26 of all of its glory.
So, I thought, could I have run him over? Did he try to get me as I was leaving and I didn't know it? I mean, I've always got the music blasting. It's snowing. I got the wipers going, the heater blasting. Did he come and hit the back of my car and I hit him in the knee and he's drunk and passed out and asphyxiated or something? And then when I hired David Yannetti, I asked him those questions the night of January 29th. Like, David, what if, I don't know, what if I ran his foot over? Or what if I clipped him in the knee and he passed out or went to care for himself and he threw up or passed out? And David said, yeah, then you have some element of culpability.
Yeah, she shouldn't have said that.
Is it a 207?
Your
That's
Honor,
not
the
good.
Commonwealth rests.
Yep, unsurprising.
Okay. Does counsel want to see me?
I bet.
We do, Your Honor.
Okay, so should we send the jury out or should?
Probably, yes.
So jurors, so everybody can sit. So jurors, the Commonwealth rests. That means that the Commonwealth's case has been presented to you for your consideration. So I need to meet with the lawyers for a few minutes, so we're going to send you back out. I can tell you that it now appears that we're at least on schedule, if not a little ahead of schedule. So we'll send you back out for a short recess.
Ooh, she could have phrased that better. That was a sloppy phrasing by her. It's now submitted to you for your consideration, so we can start considering it. Ooh, that was a sloppy phrasing. Yeah, she messed up how she phrased that. That was a bad way of phrasing that, Bev. Yeah.
Right. Can counsel come to sidebar, please?
Remember when Kurt thought the doctor started off strong and was credible? Kurt continues to think the doctor started off strong and was credible at that time. That remains my opinion. Relevant to the relevant time period. Yes. Yeah. That was a very sloppy phrasing. It's like, oh, we can start considering it? Oh. Yeah, that was bad phrasing. Yeah. They aren't going to start the defense today. That wouldn't make sense. Let the jury go home, start the defense case tomorrow probably would make a lot more sense. They were only going to do a half day anyway, so send the jury home and pick up the defense case tomorrow. Makes more sense to me. But, yeah. Yeah. Half a day to argue the motion dismissed. They're not going to spend a half a day on it. They're going to take 10 minutes and she's going to deny it. Of course she is. To her credit, what little is deserved, at least with the evidentiary picture as it exists, although that is potentially erroneous in places, which, yeah. But for a motion for a directed verdict, I think that a fair-minded jurist would not grant it. In the first trial, I think that a fair-minded jurist should have really thought about it. I'm not saying I would have done it in the first trial, but I would have thought about it. You know, I think that the evidentiary picture is better for the state than it was. The question basically is, can a reasonable jury conclude proof beyond a reasonable doubt? There's a lot of reasons that they might not be able to, or there's a lot of reasons for them to get to reasonable doubt, but sort of like the question I'm trying to assess in my mind from a purely legal posture is, could a reasonable jury, and of course, remember what the reasonable jury is as you're calculating this, right? The normal person of ordinary, average, normal intelligence, the normal person, the everyman, right? It's not it's not a particularly smart person, it's not a particularly educated person. It's just a normal person. It's not a particularly thoughtful person, it's not particularly any it's just a normal guy, right? So like, okay, so the relevant one of the relevant legal questions for a fair-minded jurist at this point would be, could a reasonable jury conclude proof beyond a reasonable doubt? Keeping in mind, of course, that the jury is entitled, as the jury instructions themselves will provide you, the jury is entitled to choose to believe parts of testimony or not, choose to weigh testimony differently or not. So basically, is there any reasonable combination? Is there any reasonable combination of the evidence that would allow a reasonable jury to conclude proof beyond a reasonable doubt? And I think sadly the answer to that question is yes at this point, as a legal question. In the first trial, I think maybe not so much. In the second trial, for all the problems, and there are many, for all the problems that are attendant, there is probably now, putting aside, of course, whether certain evidence should exist or not, which is a whole nother set of problems. Putting aside whether or not the defense was kneecapped on the questions they were allowed to ask this expert, which they were, putting aside that, which is its own set of legal errors. But like assuming for the sake of argument that the evidence is properly presented and the judge's rulings are correct, just on this ruling unto itself, would a fair-minded jurist grant the motion? And I think the answer is no, because you don't. Yeah, I don't think so. I think the state, unlike the first trial, presented a case from which a jury, of course, it's only the state's case unto itself, but that's the burden, right? The state has to be able to prove it. So did the state present a combination of evidence from which a fair-minded jurist could conclude guilt? And I think yes, unfortunately. There's a lot of evidence that, goes against. There's a lot of reasons to discount evidence, but, if you I think there's a way for a jury to get there, as much as that makes me sad inside. So, for that motion unto itself, it will be denied and probably should be denied, although there are other problems, as we've sort of been talking about as we've been doing our back of the envelope legal analysis. The confession, of course, or the perceived confession, goes a very long way. They did a much better job of presenting evidence relating to the confession, and a fair-minded jury could perceive it as a confession, sadly. And juries eat confessions up, and yeah, that gets you a very long way to home. So, yeah. Why does it make me sad inside? It makes me sad because it's not the answer I want, and it's also not the answer you want to hear. It makes me sad for these twin reasons. It makes me sad because I don't think Karen Reed should be prosecuted. It makes me sad because I think the case against her is a farce. It makes me sad because it's not the answer I want to reach. That it's not the answer you want to hear. It's not the answer that is going to make me popular or fun with, the cool kids. It makes me sad for a number of reasons. So, yeah, those are the reasons it makes me sad. I don't want to do it, but Yeah. Sufficiency of the evidence, in other words, will not be a successful ground of appeal if she's convicted. I don't know whether or not future appellate lawyers would raise the issue, but sufficiency of the evidence, it would not be a successful ground of appeal. In my humble opinion. Particularly when you think about how courts of appeal look at sufficiency, legal sufficiency. Yeah. If this goes to 3.0, you're riding. I feel that, man. If this goes to 3.0, I don't know that I'm going to cover it. I'll tell you what. Maximum Bacon says anecdotal. Criminal juries I've been on hate expert witnesses that get pedantic and deliberately obfuscate. They would hate Dr. Welcher. They may well do. Different juries react differently to different things. It's a little hard. Different juries have different dynamics. And so it's a little hard to know how they would perceive Dr. Welcher, how they perceive Alessi. They might perceive Alessi as a bully. They might not. They might perceive Dr. Welcher as credible. They might perceive him as a fool. They might. It's hard to say in any, especially because you're dealing with group dynamics of a fairly small group. There's just too much variability in any random group of 12 people to make any sort of meaningful statements. There's just too much variability about what different juries will or will not focus on, what they will or will not care about, what they will or will not focus on. It's a whole thing. Limited edition is not approved. Oh, I thought it was approved. Oh, okay, cool. All right, let me go approve the limited edition cup. I thought it was approved for some reason. Let me approve the limited edition cup. Let me do that real fast. Oh, okay. Let's do, well, apparently 2 have been sold despite it not being listed for sale. So that's exciting. I guess because it was the link allowed for the purchase, despite the fact it was, because hidden doesn't prevent it from, hidden just hides it from the store. But the link would still allow people to purchase it. So yeah, it was listed. It was therefore listed for sale. When the moderators gave the link out, it hidden just prevents it from being displayed, but it's still available as a purchase item. So yeah. Also, we're going to read that Supreme Court case dealing with the number of times a case can be tried, because it's been a while since I've read it. And I'd like to reread it. So we will reread it. And how many times can a case be retried? As memory serves, the Supreme Court didn't say there was a limit, but as memory serves, they also were sort of grousing and seem to, as memory serves, they seem to be hinting at the possibility that they might revisit the issue at some later time. But we could give it another look and see if my perception of how they wrote it is correct, because it's been a while. Can I sell private insurance policy for space cars on my merch store? I don't know how that would work. Although what I could do is, if the insurance agent makes it available as a product, I could provide a pinned link, and maybe I get a cut of any insurance policy that's sold, like a referral fee or an ad fee. I get 20% of any insurance policy that's sold on the space car thing. There's some opportunity in there somewhere. We'll talk. We'll be selling insurance riders. Excellent. How much is my cut for promoting this? Got to get that ad revenue, man. You want to sponsor this video? What the hell are they talking about at sidebar? Are they just doing the entire motion to dismiss at sidebar instead of doing it in open court? Why? I can have the whole cut. Aw, thanks. That's very kind of you. Why the Commonwealth not want to tell us? Yeah, I don't know. There's no reason it shouldn't be done in open court. I can pretty much make the arguments for both sides kind of off the top of my head. You know, the defense is going to say they haven't met their burden, they haven't provided evidence. You know, they're going to point to any flaws in the evidence. You know, they'll talk about the mistakes or flaws in the evidence. The Commonwealth will say, you know, that, you know, this is to be viewed in light most favorable to the Commonwealth, which is true. So the question isn't, you know, whether or not it's possible for a jury to find proof beyond a reasonable doubt. The question is whether or not it's possible to find proof, you know, the other way around, whichever way that is. And therefore, you know, it's up to the jury to weigh, and there's sufficiency relating to that based on, you know, the confession and based on evidence located at the scene, based on taillight fragments, based on, you know, based on the vehicle reports and based on whatever. And yeah, you're there. We can't hear the argument. I know you can't hear the argument. I understand that. They're doing it sidebar for some reason. What do you want from me? I'm just telling you what the outline of the argument looks like. Because that's what the outline of the argument looks like. I don't know exactly what they're saying, but that's effectively the outline of what they're saying. Assuming that's what they're arguing at sidebar, which if they're not, I don't know what they're talking about. Needle knows Ned would sell me space insurance. Facts. According to Turtle Boy, the only people who matter are the jurors, which, you know, yep. And based on their overt reactions, Bob Alessi convinced many of them that Judd Welcher is full of shit. They'll never be able to convict Karen Reed's disgrace that she had to hire the best lawyers in the country to save her. Maybe. Reading jurors can sometimes be challenging, you know, but, you know, fair. One person's perspective. I suppose we can begin the U.S. Supreme Court case because we're just like killing time. So let me find that U.S. Supreme Court case. What was the name of it, first of all? Because I'm going to ask ChatGPT. What was the name of the U.S. Supreme Court case dealing with the maximum number of times a criminal case can be retried? Help me out, ChatGPT. Bluford versus Arkansas? No. No. Come on, ChatGPT, give me the answer. ChatGPT is supposed to know everything. (2003) No. Richardson? Trials after hung juries? That might be it.
Please.
Oh, so you didn't switch this. Gotcha. Thank you.
ChatGPT is still trying to figure out what the case I'm trying to think of is called. Error in the input stream. Thanks. Let me ask Grok. Maybe Grok can tell me. Okay. Still, yeah. Flowers versus Mississippi. Yeah, that looks right. Flowers. Yeah. Flowers versus Mississippi. That looks right. 2019. Yeah. That looks right. See, Grok knew the answer. Thanks, Grok. Short break while the juries enter. So they argued the motion they argued for directed verdict at sidebar. Why? Why do they do that at sidebar? That's very sad. Yeah, what's that about? Why didn't they argue it in open court? Why didn't they just argue it in open court? Why argue it at sidebar? Okay.
Court is in session. Please be seated.
Hi, so jurors, we all, it happens several times a day, doesn't it? So, we don't want to waste anybody's time. I know we've spent a lot of time at sidebar, and we've had times that we've kept you in the deliberation rooms because we've been trying to sort through everything, trying to make this trial as efficient as possible, but also honoring and respecting all the hard work of the lawyers that's gone into preparing this trial. So sometimes I do understand that it's frustrating for you. But today we were able to spend some time this morning. I know we kept you in there almost a half an hour, and we've just spent some time now. So I can tell you that we are ahead of schedule right now. I still need to talk to the lawyers about something tomorrow morning. So we're going to send you home now and have you come back tomorrow morning at 9:30, because today I know we kept you until 9:30, and it doesn't make any sense where I already know I need to talk to the lawyers tomorrow morning to have you here for a 9 o'clock start. So tomorrow will be a full day, and we'll have you here ready to start at 9:30. Okay, so those same cautions.
Are they going to do the motion to
please do
dismiss in
not
the morning
discuss this case with
instead of now?
anyone. Don't do
Or the
any
motion for directed
independent
verdict?
research or investigation into the case. If you happen to see, hear, or read anything about the case, please disregard it and let us know. And also, please continue to be careful with your social media use. So we'll see you tomorrow morning.
Rise the jury.
Which means we still have to be here at 9 because the jury doesn't have to, but there's going to be argument in the morning. So our time will start the same. Excuse me. Excuse me.
All right, so Ms. Little, if you can get me whatever you're going to get me within the next hour or so, that would be great. And I'll see everybody tomorrow morning at 9
Thank you.
Okay, I guess that's the end of the court day. Exciting. Yeah, I don't know what they were discussing at sidebar and why they didn't do it now. Maybe there's, I don't know why you would need to submit. Maybe they want to submit like a memorandum. They want to put it something in writing relating to this, or like other errors they want to do relating to the. Yeah, maybe they want to put their issues relating to the cross-examination scope. They want to put that in writing. Maybe they want to do the directed verdict in writing. Maybe they want to do a trial brief, and so they need time. If they want to do a trial brief, though, they're not going to get that done in an hour. They might get done by tomorrow morning, but they're not going to get that done in an hour. That's not going to happen. So yeah, maybe that's so what they were discussing at sidebar. I don't know relating to that, but whatever. So yeah. All right. So let's discuss this case, Flowers, because it's been a while since I've read it. Which touched on this issue of the maximum number of times. Yeah, lots of scheduling talk. Yeah. So this case touched on the issue, albeit somewhat indirectly, of the maximum number of times a criminal case could be retried. And so let's read this case because it's been a while. Flowers versus Mississippi, decide 2019. Petitioner Curtis Flowers has been tried 6 separate times for the murder of 4 employees of a Mississippi furniture store. Flowers is black. 3 of the 4 victims were white. At the first 2 trials, the state used its preemptory strikes to strike all the qualified black prospective jurors. Not a great look. In each case, the jury convicted Flowers and sentenced him to death, but convictions were later reversed by the Mississippi Supreme Court based on prosecutorial misconduct. Twice? Damn. At the third trial, the state used all 15 preemptory strikes against black prospective jurors, and the juror convicts Flowers and sentenced him to death. The Mississippi prosecutors apparently have not heard of Batson. Apparently, they didn't get that memo. You can't strike jurors because of their race. Bad prosecutors. At the third trial, the state used all 15 preemptory strikes against black jurors, and the jury convicted him and sentenced him to death. The Mississippi Supreme Court reversed again, this time concluding the state exercised its preemptory strikes on the basis of rights in violation of Batson. Yeah. Flowers' 4th and 5th trials ended in mistrial. At the 4th, the state exercised 11 preemptory strikes, all against black jurors. No available racial information exists about the prospective jurors at the 5th trial. At the 6th trial, the state exercised 6 preemptory strikes, 5 against black jurors, allowing 1 black juror to be seated. Oh, how nice for them. Flowers again raised a Batson claim, but the trial court concluded the state had offered a race-neutral reason for each of the 5 preemptory strikes. I don't know, man. I don't know. On one trial, maybe. The 5th time? Oh yeah, we found really good reasons. 5 times to strike all the black jurors. We swear it's not racist. I don't know, man. I don't know. That's a lot. The jury convicted him and sentenced him to death. The Mississippi Supreme Court affirmed. After this court vacated judgment and remanded in light of Forrest, the Mississippi Supreme Court again upheld the conviction and divided 5-4. Justice King dissented on the Batson issue and was joined by 2 other justices. Holy shit. Held, all the relevant facts and circumstances taken together established that the trial court at Flowers' 6th trial committed clear error in concluding the state's preemptory strikes of black prospective jurors was not motivated in substantial part by discriminatory intent. Yeah. The Supreme Court of the United States is not buying this bullshit. So yeah, not only has he been tried 6 times, but at least 4 of those? At least 4 of those, some court has found, whether it was the Mississippi Supreme Court or the Supreme Court of the United States, at least 4 of the times, some court has found that the state deliberately struck black jurors because they are black. And we'd like to try him again, please. We'll get it right the 7th time, I swear. Wow. Under Batson, once a prima facie case of discrimination has been shown by the defendant, which the state must prove race-neutral reasons. The trial judge must determine whether the prosecution's stated reasons were actual or instead pretext. The Batson court rejected 4 arguments. First, the Batson court rejected the idea defendant must demonstrate a history of racially discriminatory strikes in order to make the claim of racial discrimination. So the Supreme Court's like, yeah, you don't have to show that they're racist in general or racist in history. Just racist now will be fine. If they're racist now, maybe they're generally not racist, but if they're racist now, that's still a problem. Racist once is still racist. Don't do the racism. Second, Batson rejected the argument that a prosecutor could strike a black juror based on an assumption or belief the black juror would favor a black defendant. That sounds suspiciously racist. Yeah, I just assume that black jurors will favor black defendants. That sounds suspiciously racist. Yeah. Third, the Batson court rejected the argument that race-based preemptory should be permissible because all black, white, Asian, and Hispanic defendants and jurors were all equally subject to race-based discrimination. No, I mean, I suppose if you're racist against everybody, but if you're racist against everybody, you're racist against nobody. So you actually can't be racist against everybody. That's actually not possible. You're just then a jackass, right? And there's actually case law on point, which I always find hilarious. This comes up most often in sexual discrimination cases in the workplace. And it is, in fact, a valid defense that I am not a sexist. I am just an asshole to everybody. That actually is a valid defense. I might have treated the woman like complete shit and garbage, but I treat everyone like complete shit and garbage. I just hate everybody. Misanthropy is, in fact, a defense to racism and sexism. So, but you actually have to be racist and sexist. The fact that you could, in principle, be racist against any one of them is not the thing, right? Like, I mean, in principle, I'm not racist against black people. Maybe in principle, I'm only racist against the Asians, or I'm only racist against the Hispanics. So, that's equal opportunity. No, you still have a problem, sir. If you're in fact racist against everybody, then I guess, but the fact that, racism is something, everyone can be racist and different people are racist in different ways is not going to work. But we appreciate your enthusiasm. Fourth, the Batson court rejected the argument that race-based preemptories are permissible because both the prosecution and defense could employ them. And essentially that balances out. Oh, that's good. Yeah, so it's fine for the government to be racist because, well, the defense could also be racist. And that it all works itself out. Because everyone gets to be equal, everyone gets to be racism, and the racism will cancel each other. The Supreme Court's not buying that either. They're like, no, you can't do the racism. The racism doesn't balance itself out. You might be racist against any number of races, but you can't be racist unless you're racist against everybody. Racist against everybody is fine, but otherwise not so much. And yeah, no. 4 categories of evidence loom large in assessing the Batson issue here, where the state had a persistent pattern of striking black prospective jurors. Yeah, that does seem to be a bit of a problem in that case. A review of history of the state's preemptory strikes in Flower's first 4 trials strongly support the conclusion. The use of preemptory strikes in the 6th trial was motivated in substantial part by discriminatory intent. Yeah, we can't help noticing you struck. Yeah, I mean, that's actually like if we were in a criminal case and we were doing propensity evidence, this would be an argument against propensity, right? Because it shows a history, a pattern of practice, right? So if you were in a criminal context where you were saying this is propensity evidence, it would be a valid thing to show no. It shows absence of mistake, it shows motive, it shows it's not just mere propensity for the sake of propensity. It is a pattern of conduct. And so, yeah, I mean, yeah. So the fact that you did the first 4 times kind of might suggest that was your motivation the 6th time. Yeah, that makes sense. The state tried to strike all 36 black prospective jurors over the course of the first 4 trials. And the state courts themselves conclude the state had violated Batson on at least 2 separate occasions. The state's relentless, determined effort to rid the jurors of black individuals strongly suggests the state wanted to try Flowers before a jury with as few black jurors as possible, and ideally before an all-white jury. They might be a little racist. Disparate questioning can be probative of discriminatory intent. Here, the state spent far more time questioning the black prospective jurors than the accepted white jurors. Because it's like we were looking for a reason, right? So we kept asking questions till we could find a reason. Right? Because if we did have a valid reason to strike you, because it's only racism if we're doing it because of your race. That's true, generally speaking. Right? That is a generally correct statement. It is only racism if racism is at least part of, or if race is at least part of the reason. If I'm doing it for reasons other than that, the fact that you're black is irrelevant. It's not racist. That's true under the Civil Rights Act. It's true under the Constitution, right? So if I am actually striking all black jurors in reality because I have a valid reason, it is not racist. That is true. The fact that all the black jurors had a valid reason just happened to be the way the cookie crumbled. But the Supreme Court's like, we can't help noticing that you spent a lot more time questioning the black jurors than the white jurors. It's almost like you were searching for an excuse. See, it reveals your real reason. Your real reason, because this all gets to what really were you doing? What is your real reason, in fact? So we can't help noticing that you spent a lot more time with the black jurors, almost like you were searching for a reason to provide cover. And you know what that's called? That's called a pretext. That's called a pretext. And we don't allow the pretext. Pretext is bullshit. So yeah, you can't do that. Here, the state spent far more time questioning the black prospective jurors than the white jurors. 145 questions asked of 5 black jurors and 12 questions asked of 11 jurors. That does seem to be pretty disproportionate. We asked 145 questions of 5 black jurors and 12 questions of 11 jurors. Those are pretty widely different numbers. The record refutes the state's explanation. It questioned the black and white prospective jurors differently only because of difference in their characteristics. Would the characteristic be because they're black? Along with historical evidence from earlier trials, as well as the state striking of 5 of 6 black prospective jurors at the 6th trial, the dramatic disparate questioning and investigation of the black jurors and white jurors at the 6th trial strongly suggests the state was motivated in substantial part by the discriminatory intent. Yeah, I mean, again, it does seem to have been a large motivation of your reason. Yeah. Comparing prospective jurors who struck and not struck can be an important step in determining Batson. Here, Carolina Wright, a prospective black juror, was struck. The state says, in part because she knew several defense witnesses and had worked at Walmart, where Flowers' father also worked. But 3 white prospective jurors also knew many of the individuals involved in the case, and the state asked them no questions about their connections to the witnesses. Yeah, that doesn't really track, right? We struck the black juror because she knew one of the witnesses in the case, but we also allowed 3 white jurors to sit, even though they knew witnesses in the case. That doesn't seem like that tracks. That's a little sus. That's a little sus, man. White prospective jurors also had a relationship with members of the Flowers family, but the state did not ask them follow-up questions in order to explain the depth of that relationship. Yeah, we know members of Flowers and the Flowers family, but we have no further questions relating to that. That's good, as long as they're white. The state also incorrectly explained it exercised preemptory strike against Wright because she had worked with one of Flowers' sisters, and apparently incorrect statements to justify the state strikes of other prospective black jurors. So we can't help noticing that when you said you did certain things, you're lying. You said certain things, but we read the record and not so much no. That didn't happen. When considered with other evidence, a series of factually inaccurate explanations, that's one way of putting it, Supreme Court. We might want to go with lying. Did they lie? Did they lie to the Supreme Court? Don't do that. That's a bad thing. For striking the black prospective jurors can be another clue in showing discriminatory intent. The overall context here requires skepticism of the state's strike. The trial courts at Flowers' 6th trial committed clear error in concluding the state's preemptory strikes was not motivated, reversed and remanded for another exciting trial. Okay, so yeah. And then I seem to vaguely recall there was some language somewhere in one of the opinions dealing with like the fact that this is the 6th trial or something that should be like a forfeit. So I seem to vaguely recall some language relating to that. So let's skim it and see if there's language relating to that. So excuse me while I skim. It might have been in a concurring opinion. It might have been in a dissent. But I seem to recall some language somewhere that the Supreme Court was like, maybe there should be a limit. Or more, maybe it wasn't because of the number of times. Maybe it was because of the fuckery. So maybe it wasn't because it was 6. Maybe it was because it was 6 racist. And maybe how many racist bites do you get at the apple? How many times do you get to be racist before you just forfeit? That's a good question. So maybe that was what the Supreme Court was pissed about. It's been a while since I read it. Why doesn't jeopardy attach after prosecutorial misconduct? See, that's a really good question. And maybe that's what the case talked about at some point. It's definitely not the thrust of the opinion, but I seem to vaguely recall there was some language somewhere in it. Maybe I imagined the language. It's been a while. Blah, 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 blah. Still talking about whether or not they're racist. We're still talking about whether or not the racism is bad for a while. We're talking about whether or not racism is bad in jury selection for a while. We're still talking about whether the racism is bad. We're going to talk about Brown versus Board. We're going to talk about whether racism is bad for a while. Blah, blah, blah. Blah, blah, blah. Still talking about whether racism is bad. Lord. So now we get to Batson. Then we talk about Batson, where we're like, yeah, the racism is a problem. So we're going to talk about Batson for a while. I thought we decided Batson like 60 years ago, 70 years ago, but whatever, that's fine. Still talking about racism and whether the racism is bad. Blah, blah, blah. Okay, also, since Batson, we've continued to affirm the racism is bad. So just in case there was any question about it, since Batson was decided in the 60s, we have continued to say, you know what? We still think the racism is bad. Maybe don't do the racism in the jury selection. I don't know why we have to keep reminding you the racism is bad, but we do for some reason. We have to keep reminding you the racism is bad. Also, literally in this case, we're literally reminding you once again the racism is bad. So yeah, we've said it several times, and we're going to say it again, like literally right now, because some of you guys apparently didn't get the memo. somehow the first like 8,000 times we said it. So we'll say it again. Blah, blah, blah. Blah, blah, blah. Talking about how Batson works, like that was confusing for some reason. Still talking about it. All right, having decided that racism is bad, let's talk about it in the context of flowers. The Constitution forbids striking even a single juror because of racism. Yeah, one is enough. In case we needed to know what is the number, how much racism? Is a little bit of racism okay? How many jurors can I strike for the racism? How about 3? Can I strike 3 jurors for the racism? Can I have a 3-juror limit for the racism? Am I limited to 3? And the Supreme Court's like, how about 0? Can I have 1? How about 1 racism? Can I get a racism freebie? Can I get a racism mulligan? How about 1? Supreme Court's like, no, not so much. You can't strike even 1 juror. Even 1 juror for the racism. I'm not sure why we have to spell this out, but in case we do, not even 1. So 1? No. Blah, blah, blah. Still talking about it. So then we're going to try to decide whether, so the lower court, the Mississippi Supreme Court said, we don't see any racism. We don't see the racism. We don't, it's fine. After all, the prosecutor did in fact allow 1 black person to sit on the jury. So they're improving. So that's good enough, right? They did in fact allow 1 black person to sit on the jury. So progress. No. Blah, blah, blah. Still continuing. Talking about the history of the thing in case we needed to clarify that. So to the extent there was any ambiguity about what they were doing in the 6th trial, the first 4 trials are somewhat informative. Blah, blah, blah. Still continuing, talking about this for a while. We cannot ignore the history of the first 4 trials. Yeah, I mean, retrials are sometimes a redo. Sometimes they're a do-over, but, not always and not completely and not in every way. So we're not doing that. So we're going to talk about how they treated the jurors in the 6th trial with respect to the preemptory trials. We're now going to talk about this and the voir dire. Yeah, in the 6th trial, in the 6th trial, on average, the state asked 29 questions for each black juror, but an average of 1 question for each white juror. We can't help notice that 29 is how many more than 1? That's a complicated math problem. I don't know. Yeah, what level of magnitude? By what factor is 29 more than 1? By what factor is 29 more than 1? What number times 1 equals 29? I am so confused. Continuing on. We only did it because of differences in their characteristics, so now we're going to go through your pretext and say how that's some bullshit. Why did the state ask so many more questions and conduct such a more vigorous inquiry of the black jurors? No one can know for certain. I don't know, man. I don't know. I feel like we can know. I mean, it could be not racism. I suppose it is possible. It could be not racism, but feels feels a little sketchy. Continuing on, finally in combination, we can determine it was racist. Great. So there was some racism. Then we talk about Carolina Wright as one of the jurors because anyone will be fine, right? Having determined that one racism is enough, we can then just talk about one case because one is enough, right? Simplifying our lives. So were they racist to Carolina Wright? Yes, great. Moving on to other things. Blah, blah, blah. Blah, blah, blah. Still talking about this for a while. Blah, blah, blah. The incorrect statement was not the only one made by the prosecutor. The state made apparently incorrect statements to justify the strikes of several jurors. Incorrect is a very charitable way of saying it, right? And it was incorrect. We're not going to say lie, but yeah, okay. We'll just say incorrect. In a different context, it might be permissible, blah, 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 continuing on. In some, the pattern of striking jurors fell through the trial. To reiterate, we do not decide any one of the factors would require reversal. Yeah, we don't need to decide any one of those is sufficient. We just need to decide that, all of them together is sufficient. Please don't ask us to decide further questions. What about three of them? What if three of them? Oh, God. So we reverse. So the majority opinion doesn't really decide. The majority opinion doesn't really decide or discuss the issue relating to maybe the fuckery should prevent you from doing it. But all right. So then Alito, this case is likely one of a kind. I'm not sure that's necessarily true, but it's definitely different. So did Alito discuss issues relating to yeah. Justice Thomas doesn't discuss it, I'm quite sure. Did Justice Thomas dissent? What a prick. Justice Gorsuch dissents as to parts 1, 2, and 3. All right, I'm a Justice Gorsuch fanboy. I am a Justice Gorsuch fanboy. So we will give Justice Gorsuch his due. Because, all right, Justice Gorsuch, explain to me. It probably comes down to something dealing with the standard of review or something. That the lack of deference to the lower court is probably where this is going. But I don't know, Justice Gorsuch, you're going to have to sell me on this one. But let's see what you got. So we talk about the murder. The murder was bad. The murder was bad. And gruesome. The issue, the day does not dispute the evidence is sufficient or is tried by an impartial jury. I don't know that that's correct. They think that there's a problem. Instead, they vacate the conviction on the ground the state court clearly erred in finding it did not discriminate. The only clear error is decided by the majority? Really? Confirming that we should never have taken the case, the court almost entirely ignores and certainly does not refute the race-neutral reasons given by the state. They think it's pretext. That's the entire majority opinion. It's not like those reasons weren't true. It's that they were pretext. So they didn't refute them because they were real. They were just not the real reason. They were real reasons. They just weren't the real reason because of the things the majority discussed. The state court finds these strikes were not based on race or the opposite clear aloneness. They're clearly correct. Really? The court attempts to overcome this evidentiary race neutrality by pointing to supposed history of discrimination in the previous trials. Well, also they pointed to the number of questions asked of this particular jury. But yeah, the previous trials is going to be at least partially informative, one would imagine. But 49 of the state's 50 strikes were race neutral. How are you coming to that conclusion? 49 of the state's 50 strikes in the previous trials were race neutral? How are you coming to that conclusion? Today's decision distorts the record. Twice now, the court has made the mistake of granting this case. Uh-huh. I'm having a tough time justifying this one, Justice Gorsuch, with all due respect. Justice Thomas can be a pain in the ass sometimes. But Justice Gorsuch, I want better of you. This makes me sad. This makes me sad. Sorry, I lost the chat for a second. I had to reload it. Flowers then filed another petition for certiorari raising the same questions where a prosecutor under ordinary certiorari would never grant the issue. There's no disagreement among lower courts and the court case question is not implicated. So you think, okay. Nonetheless, Flowers' question presented at least had the virtue of being a question of law that could affect the Batson. Unchastened by the remand, however, the court grants cert and change the question presented, which the Supreme Court can do. The Supreme Court can change the question presented. It's not usual, but they can do it. Because sometimes the Supreme Court asks its own question. Okay. In other words, the court tossed aside any pretense of resolving a legal question, so it reconsidered the factual finding. Well, I suppose in some sense, because they're trying to determine whether the finding was clearly erroneous. So yes, they are, in fact, the Supreme Court is, in fact, taking up an appeal on an issue of fact, which, to be fair, is unusual. And a reversal on an issue of fact is unusual because a lot of discretion is given to the lower courts. So yeah, this is unusual for an appellate court, and it is unusual for the Supreme Court because they're not saying the law was wrong. They're not questioning whether the lower court had the right law. They are in fact challenging the lower court on an issue of fact. That's pretty weird, especially for the Supreme Court. But, that's apparently what we're doing right now. It's also a little weird because it is arguably just trying to change an erroneous legal conclusion using the right law, which is a disfavored reason for the Supreme Court granting review. So the Supreme Court, it does not, to be fair, in some limited sense about the reasons for granting cert. To be fair to the dissent, although these are really issues dealing with the reasons for granting cert rather than the merits of the decision, it is an unusual posture for the Supreme Court to grant review. It doesn't really have the standard markers, although this case is a bit unusual in the different sense because of the number of retrials. And also it's a death penalty case, which also makes it a bit special, but it doesn't really have the standard markers, right? There is no issue of circuit split because there's no issue of law that's in dispute, right? So there can't be a circuit split because there's no issue of law that's in dispute. There's no one's questioning the law, so it's not a circuit split. It is not of extraordinary importance relating to like issues dealing with fundamental structural issues, relating to issues of federalism or relating to the balance of powers between the branches. So it's not important in that sense. It doesn't have broad implications. It's just one guy's case. And issue number 4 is, do they really want to beat up on the Mississippi court for the hell of it? It doesn't, I don't know. And also, it is in the Supreme Court rules itself. There's actually a rule basically on this exact issue. The Supreme Court, in its own rules, basically says if you are coming to us not because they got the law wrong, but because they misapplied the law, don't come to us, right? We don't do just mere error correction in terms of they had the right law, but they simply applied it wrong. That is not why we're here. So, in that sense, and it's actually arguably even worse than that because it's arguably not even a misapplication of law, though you could argue it is because you misapplied what clearly erroneous is. So whether or not this is a legal error or a factual error, I suppose, is slightly in the eye of the beholder. But it's arguably not even a legal error. It's arguably a factual error. And so that is like a very, very odd posture for the Supreme Court. So I suppose, but then again, this case is kind of fucked up. It is the sixth time and it is a death penalty case. And, death is different, as the Supreme Court has noted on more than a few occasions. So, but those are at best reasons not to grant cert, not on the merits of the thing. So I don't know about that. Seems odd to me. The court does not say why it disregarded our traditional criteria. I mean, fair. Yeah, I mean, basically, you just have the sheer outrage of it all is basically the fact that it's a death penalty case doesn't hurt. But yeah, it is an unusual posture for the Supreme Court. I mean, that is true. But the case is a little fucked up. It's not as if the case lacked better options. Well, they are. Yeah, and it's also the Supreme Court is not really in the business of fixing one guy's problem. That is, the Supreme Court doesn't just try to fix one guy's problem because they have better things to do with their time. And basically all they're doing is fixing one guy's problem. That's all they're doing in this case. Because again, this case appears to be fairly unique. Because yeah, so they're just fixing one guy's problem. That's pretty unusual for the Supreme Court. So I mean, yeah, I guess. The court grants cert because the case received media attention? Really? Really, dissent? You think the U.S. Supreme Court granted this because they wanted the media attention? Seriously? Wow. Okay. Whatever the court's reason for taking the case, we should dismiss it as improvidently granted. Why? If the court wanted to simply review the state's application of Batson, it could at least have the decency to do so the first time around. Well, they reversed to ask them to look at something else. Yeah, the Supreme Court reversed to ask them to take a closer look at a particular case. So they didn't address Batson the first time around because it's like, could you take a closer look at this issue with respect to this particular case? And then they did that. And they're like, yeah, we still don't think there's a problem. And so the Supreme Court's like, I guess now we have to do it. So I suppose the Supreme Court could have just decided the issue the first time around, but they wanted to give the lower court a chance to get it right. So that was somehow a mistake, I guess. I don't know. The majority considers a point of pride to break no legal ground. Yeah, there's definitely no new law in this case. Pretty unusual for the Supreme Court. There's no new law. And proceeds to second guess the factual finding of two different courts on matters wholly collateral to the merits. In the strictest possible sense, that's true. It is strictly collateral to the merits, but holy shit. If nothing else, effort proves the reasons behind the rule is we do not take intensely fact-specific cases. Yeah, we don't normally do that, but we're the majority opinion is so manifestly incorrect, I must proceed on the merits. Okay, Flowers presents no evidence whatsoever of purposeful race discrimination by the state. Okay. Each of the 5 challenge strikes was amply justified on race-neutral grounds. Technically, none of the struck black jurors was remotely comparable to the seated white jurors. And nothing about the state's conduct, whether trivial mistakes of fact or supposed disparate questioning, provides any evidence of purposeful discrimination. Really? You don't think the fact that they asked the black jurors 29 times more questions than the white jurors might be suggestive they were hunting for a reason? You don't think that might be a thing? The majority focuses its discussion on potential juror Carolyn Wright, but the state offered multiple race-neutral reasons. Yeah, that's okay. So then we're going to talk about the race-neutral reasons, which, fine. I concede that there were race-neutral reasons to strike her. I will concede the point. That's not the end of the game, though. Blah, blah, blah. Finally, the majority dismisses the lawsuit's significance. Yeah, but the state had additional race-neutral reasons. Yes, okay, I will concede. I will concede dissent. The state had many race-neutral reasons to strike Wright. They had lots of race-neutral reasons. I'm super excited. Was race one of their reasons? If so, that's a problem. The majority, while admonishing trial courts to consider the prosecution's race-neutral explanations, completely ignores the race-neutral explanations. I don't think they ignored it. They just found it to be pretextual. They didn't ignore it. They're like, it's just bullshit. Saying it's bullshit isn't ignoring it. They're like, it's just lies. Okay, then they're going to talk about all the other race-neutral reasons they struck all the other black jurors. That's exciting. In terms of race-neutral validity, these 5 strikes are not remotely close. I'm having a really hard time justifying this one, Gorsuch. Only by ignoring these facts can the court assert the state's decision to strike 5 of 6 black jurors is further evidence suggesting the state was motivated in substantial part by discriminatory intent. Blah, 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 blah. So maybe there was no discussion. So maybe I just imagined the discussion relating to the maximum number of times, because I don't see any discussion relating to that issue. Whether as a maximum number of times, as a general proposition, or because they fucked around on race and therefore they should forfeit. I don't see any discussion in the opinion relating to that. So maybe I just imagined those. Maybe that was just part of the oral argument or something, but not part of the decision itself, because I'm not seeing any language on that. So I suppose I have to retract what I said, because I don't see any language dealing with that issue at all. I don't even see a footnote, although I'm skimming. Yeah. So, yeah. So there apparently is not any, there might be some dicta in other cases, though, to be fair. So, there might be some dicta or some musings in some past cases, but, without doing a full briefing on the issue and going through, extensive history, there is currently no Supreme Court language relating to a maximum number of times you can be retried, even if the reasons for retrial is the state's absolute total fuckery, let alone just because of the sheer number of them. So those apparently are not, there might be some language somewhere. There's probably language in courts of appeal decisions. I believe that for sure. But there apparently is maybe some sort of passing musing somewhere in a tea leaf, but nothing that would really reflect the Supreme Court's view. So I thought there was more here than there was. So my memory of the case was inaccurate. which is, always good to refresh yourself and remember what it said. So exciting. Did I try asking ChatGPT? I did a little bit, but I was only asking it to look for the case I was thinking of. I didn't, and ChatGPT, we can ask ChatGPT though to see what it says. We can ask it and see what it has to offer. Give me a second and I'll bring it up. All right. Let me bookmark this so I have it as well. All right, let's ask ChatGPT. We'll use O3 because O3 tends to be the best on research, I think. Okay. I am interested, and I'll obviously search the web. I'm interested in federal appeal cases or U.S. Supreme Court cases that suggest there is or should be a maximum number of times a criminal defendant should or can be retried consistent with the Constitution. Please please find federal appeal cases or U.S. Supreme Court cases that either discuss this outright or allude to it in the discussion. Also, consider any law review that discuss this issue. Also consider whether it matters that the retrial occurred due to prosecutorial misconduct or not. Please provide a summary of the. Please provide a discussion of notable cases, and please provide notable cases, notable law reviews, and also a summary of the state of the law relating to this matter, this legal question. Should we ask for deep dive? If we ask for deep dive, it's going to take like 8 minutes to do the search, but it could be interesting if we ask for deep dive. But if we ask for deep dive, is there anything else I should ask the question? Because if we're gonna spend 8 minutes of ChatGPT research time on a deep dive, is there anything else or any other way I should ask this question? Is there other elements to the question I should ask? I'll wait to see if there's any other suggestions. I'll do deep research on this. Recommendation for a retrial limit? No, I want to know what the legal scholarship has to say on the issue. You can't think of anything else? Okay. All right. Let's run that and see what we got then. Am I primarily interested in cases post 1981? I am interested in any cases. Earlier precedent is acceptable. However, also consider whether there is any trend in the precedent that suggests the courts are heading toward a eventual conclusion, even if there is no consensus at this time. Am I looking for specific types of criminal cases? No. Consider all criminal cases. Limit coverage to federal decisions. Federal court decisions, and law reviews. Okay. Consider discussion relating to the constitutional guarantees relating to double jeopardy and due process. In particular, consider. All right. All right. Well, now we get to wait for a couple minutes while ChatGPT is thinking. So, what do you guys want to talk about while we're waiting? Let's see. There's a final ruling relating to the buffer zone that we can read while we're waiting. So let's read that while we are giving that a go. So while we're waiting for ChatGPT to think, let's discuss the issues relating to the buffer zone. Let's see. Where are you, Chat? Okay. Thank you for the 360 of you who are still tuned in. Some of you are interested in this. All right, so this is from the Federal District Court relating to the buffer zone issue. How long is this decision? 20 pages? So we'll skip the background because we know the background. Yeah, we don't need to discuss the background. We know where we were. Blah, 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 blah. police enforcement of the buffer order. So, a couple issues relating to the buffer zone. So they discuss a couple specific people. We can get into that if we need to. Defendants argue the claim is moot because even though he's initially prohibited protesting, it's since been permitted to quietly protest. I disagree. Yep. When during litigation, defendant ceases to engage in challenge conduct and restores the status quo ante, the lawsuit may or may not be moot. Supreme Court said that the case is moot only if the defendant meets the high burden of persuading the court that's absolutely clear, cannot be reasonably expected to reoccur. That Mr. Grant, one individual, has been allowed to protest quietly with his one sign does not make it absolutely clear it cannot be expected to occur. Unlike in other contexts in speech, we may assume a substantial threat of future enforcement absent compelling contrary evidence. It is undisputed the high-profile Karen Reed trial is ongoing and continues to engender public interest. Defendants dispute the plaintiffs have shown are likely to succeed on their claim. Thus, the claim is not moot. To show standing, the plaintiff must show real and immediate injury. Defendants argue that they have not suffered cognizable harm. Defendants are correct that no showing has been made the buffer's orders were directly applied to them. However, crediting allegations of fear to engage in protesting due to enforcement of the buffer zones, I find they've shown sufficient injury. They allege the zones have resulted in ongoing chilling effect of their speech. Shown other protesters have been unlawfully prohibited. Preliminary injunction is extraordinary. That's true. Likelihood of success. Plaintiffs allege their First Amendment rights are being violated because they're content-based. Plaintiffs further argue the buffer zones are unconstitutionally applied. Blah, blah, blah. The parties do not dispute the speech at issue is protected by the First Amendment. Instead, they dispute whether it's content neutral. The supplemental order keeps intact the prior order as applied to pathways and bars noisy protests, including those using amplifying sounds, honking horns, or yelling, and display of written or graphic materials that are intended to interfere with the administration of justice within the buffer zone. Yeah, but that's the language the First Circuit explicitly wanted because it goes to the mens rea. And it's also content neutral in its application. Although any protest against defendants support of the Commonwealth will be equally subject to restrictions, the supplemental order requires authorities to examine the content of the message, determine whether the violations occurred. No, not really. You can determine intent from other ways. And to the extent it does, the case relating to billboards from Austin, City of Austin, would suggest that that still is content neutral. So yeah, even though you have to read the signs, City of Austin would imply that that is still content neutral. A somewhat weird determination, but yeah, so I don't think so. It's content based. Yeah, I don't know in light of City of Austin that that's correct. That it's content based. And also the First Circuit explicitly said that this language would be fine. So you can't turn around and disagree. No. I mean, to the extent there's law of the case, which is fine, the First Circuit said this would be fine. So are you going to turn around and disagree with the First Circuit? That doesn't make any sense. So not only is it not consistent with City of Austin, it's not even consistent with this case, the appellate decision in this case. In remanding, the First Circuit identified lax mens rea. In response, they incorporate mens rea. Plans do not meanly can tell there's interest. Instead, they argue they're not narrowly tailored. Bullshit. And it doesn't have to be, yeah, because they're going for least restrictive means. Yeah, they're not going to find it's least restrictive. I'm not sure that this is consistent with law of the case. District Court. I think you're going outside your wheelhouse. I think you're going to get smacked down on appeal again. Okay, you defer to the trial judge? Okay, on the issue? All right, fine. They challenged the meaning of interfere with the administration of justice, but that's language from the First Circuit. On this issue, you are bound by Cox. Yeah, you are, because the First Circuit bound you, you jackass. It's like you're mad at the First Circuit. You're mad at your boss. Blah, 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 blah. Although not explicitly argued by inclusion in the record, signs that Rev Bev court is a clown show. And Judge Canoe is correct. I surmise the plaintiff's quibbles with the inclusion of the judges and court officers as classes of individuals need protection. After all, they're expected to wear a fair amount of criticism. In the context of the present case, prohibiting direct attacks to the credibility and authority of the judge and trial judge are permissible restraint. Okay, so you're not happy about it, but you're going to listen to the First Circuit. Fine. You're going to be pissed about it, but you're going to do it. So you're going to put the fries in the bag. But you're going to be really angry about it while you're doing it. Okay, fine. So therefore you conclude it is narrowly tailored. How nice of you. So you think it meets strict scrutiny. Okay, fine. Have it your way. Substantive due process is not unconstitutionally vague. How could it be? Because again, the First Circuit applied this language. As applied language, as applied challenges. If the buffer zones are narrowly tailored, plaintiffs argue the application is not. On this score, plaintiffs have a winning argument. They might. The First Circuit has held that while statutes valid on its face, still possible enforcement against a particular person could be invalid as applied. Here, although the buffer zone orders are clear, the record shows persistent threats of arrest to people who are complying with the buffer zone. So yeah, maybe as applied, there are challenges. Yeah, fair enough. Fair enough. I take no particular position on the as applied challenges. Blah, 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 blah. The likelihood of success, the buffer zones as applied deprive these protesters. Maybe. I could get into it in the details, but I can't be bothered right now. There's no need for extensive analysis of irreparable harm. They've shown a likelihood of success on the First Amendment. Balance of equities, fine. Conclusion, for the reasons stated below, temporary restraining order and preliminary injunction is denied in part and granted in part. Law enforcement officers are enjoined from enforcing the buffer zone orders in ways that are inconsistent with this decision. Okay, okay. So they're just basically like, please stay in your lane, which was already the order. So this is, this is kind of a lame decision because it's like, yeah, just make sure that you stay within the bounds of the order, please. Police officers. So I guess, but fine. Fine. Any updates on Polymarket? Let's take a look. As of today, or as of right now, with $127,000 being bet, Karen Reed to be found guilty of count 1 or count 2, 27%. With $64,000 being bet, Karen Reed to be acquitted of all charges, 54%. Those sound like reasonably plausible numbers. I don't have a major contention with those numbers. So that sounds reasonably plausible. But that's what Polymarket is saying on the issue relating to that. So if you want to bet, there you go. Exciting. I suppose while I'm waiting, I could also create the thumbnail for tomorrow. And create the stream for tomorrow. That'd be a good thing to do while I'm waiting. All right. Tomorrow is May 30th. It is day 24. We need a new background to make it look pretty. Let's see what's available. That one might be a little busy. This sunset one's not bad. This would be interesting. That'd be different, but let's give it a shot. Come on. Come on. Fighting with the computer. I hate fighting with the computer. Just do what I want, computer. Canva has decided to crash, apparently, so I can't create a new thumbnail. That's fun. Let's see. Canva has apparently decided to completely crash. Exciting. No new thumbnail for Uncivil. Okay. Well, I guess I could create it without a thumbnail and fix it later. Let me do that. I'll create it without a thumbnail and fix it later. All right, so this is going to be on the 30th. It's going to be at 7:45 a.m. Wait, they said 9:30. That's 8 my time. Yeah, 7:45 a.m. Okay. This is going to be day 24. It's going to be May 30th. I'm going to create it without a thumbnail for now. Unless Canva decided to load finally. Okay, that looks good. I like that thumbnail a lot. That's cool. All right, so let's see. Upload thumbnail from downloads. That's the wrong thumbnail. There it is. Okay, that's good. Let's see. May 30th, day 24, right? 7:45 a.m. on the 30th. Great. Create that. Create that. Schedule it. Wait for it to be scheduled. And it's still waiting for the scheduling to happen. Okay, schedule is complete. Great. Now I have to go over to the live stream feature and schedule up the redirect for tomorrow. Yeah, that's a not bad looking thumbnail, I think. All right, and change the settings for tomorrow as well. Well, I'm thinking about it. Okay. Turn off ads. Subscriber mode. Slow mode. Set that for tomorrow. Excellent. All those settings are saved. Great. All right, let's take a look at what ChatGPT created while we've been waiting and see if it created any thoughts on the issue. All right. So on the issue of maximum retrials, what did ChatGPT say on the issue? Uh, yeah. Double jeopardy clause protects defendants from being tried twice for the same offense, but its application of repeat mistrials and retrials has limits. In practice, if a trial ends without a final verdict, the government is generally permitted to retry a defendant. Indeed, as one commentator observes, for those facing hung jury retrials, it's as many times as the government pleases. Double jeopardy prohibitions do not apply when when they fail to reach a verdict. The answer explores U.S. Supreme Court and federal appellate case law on whether the Constitution limits the number of retrials, either under double jeopardy or due process, and whether any case suggests a maximum number of trials. Also examines the role of prosecutorial misconduct in the cases barring retrial and highlights key law review articles. Okay. We'll see what it has to say on the issue. Under Supreme Court precedent, retrial is generally permitted after certain non-final trial outcomes. In Perez, the Supreme Court established that mistrial due to a hung jury is not acquittal for double jeopardy purposes. The manifest necessity of discharging the deadlocked jury allows the government to retry the case without violating double jeopardy. In modern terms, a hung jury does not terminate jeopardy, so a new trial on the same charge is constitutionally permissible, citing Richardson. Likewise, the defendant's conviction is reversed on appeal for trial error. The general rule is the government may retry the defendant. The Supreme Court, United States versus Teto, stated it's not unfair to afford the prosecutor one full and fair opportunity to obtain a conviction when the conviction is set aside due to error. However, there's one critical double jeopardy limitation. If the appellate court reverses a conviction solely for insufficient evidence, then retrial is barred. That makes sense. So in the event they say there wasn't enough evidence, then you don't get another bite. That's fair. In some, double jeopardy doctrine allows multiple trials in many circumstances after mistrials, including hung jury or reversible errors, but after final acquittal or equivalent, such as insufficiency. As to multiple hung juries, there's no fixed numeric limit in the Constitution or federal rules on how many times the government can retry. As a practical matter, most prosecutors will reassess a case after one or two mistrials, but legally they could persist. Federal Rule of Criminal Procedure 31B implicitly recognizes that a jury is discharged without reaching a verdict. The action may be tried again. Apart from constitutional considerations, no statute or rule sets out a maximum number. That's correct, generally speaking. Thus, a second or third trial following mistrial is not automatically forbidden by double jeopardy. For example, Second Circuit expressly allowed a third trial after two hung juries, making clear that neither double jeopardy nor any per se rule bars prosecution from continuing. In fact, the Second Circuit reversed the district judge's attempt to dismiss an indictment after two mistrials, emphasizing that double jeopardy was not violated by proceeding to a third. Other courts have similarly held that multiple trials are permissible. The Supreme Court has consistently treated a jury deadlock as an instance of manifest necessity, thereby allowing retrial. Even where a defendant has endured several trials due to deadlocks, the court have not recognized a bright line cap. I'm not aware of anyone. I don't know if there's anything even on the appellate level on this. The key double jeopardy inquiry for mistrials is whether the termination of the prior trial was necessary. The defendant consents, then it's allowed. If defendant declares mistrial of objection, must be supported by manifest necessity. When mistrial lacks manifest necessity, then double jeopardy would bar mistrial, which we already knew that. However, mistrials are properly declared, they uniformly hold that jeopardy continues and new trials allowed. The bottom line is under current law, double jeopardy possesses no absolute limit on the number of retrials. Although the double jeopardy clause has not been interpreted to set a hard limit, the Supreme Court has acknowledged in dicta that at some extreme point, due process might be violated by repeated efforts to convict. In Barkas versus Illinois, the court upheld a state conviction that allows federal acquittal, dual sovereignty scenario, but in doing so cautioned that at some point the cruelty of harassment of multiple prosecutions by a state would offend due process. Yeah, so yeah, there is some. Yeah. The court has ruled out at some point the cruelty of harassment by multiple prosecutions would offend due process. The specific limitation imposed on the federal government did not bind the states. So, assuming such a limit does exist, whether it would bind the states is, of course, a separate problem. It probably should, but I suppose it's a separate question. Decision is a 20-page ruling. I know we skimmed the important parts. We read the buffer decision. We skipped a lot of the background. We skipped stuff relating to we skipped the background because we know it. We skipped the stuff dealing with the as applied challenge because it's a little fact specific and sort of got to the crunch. I know. We read it. I'm well aware. Quoted language is fundamental fairness could be violated by indefinite string of trials. Due process might prohibit the government from harassing a defendant. However, the court has never established a clear test or numeric threshold. The Baucus concept remains a theoretical limit. Hypothetical due process line has not been established. Lower courts have occasionally grappled with the issue. Some defendants have argued a third or later trial after hung jury violates due process. These arguments have generally not succeeded in federal courts absent extreme misconduct. The Michigan Supreme Court once confronted the question, expressed skepticism about drawing a due process line any number of retrials. If 3 trials are too many under substantive process, why not 2? Most courts therefore have declined to find a substantive process. That said, there are rare instances of a judge halting further prosecutions in the interest of justice. Famous examples: United States versus Ingram, a federal district decision. In Ingram, the defendant had been tried twice for bank robbery. Both trials ended in hung juries with overwhelming majorities to acquit. After a second mistrial, the judge dismissed the indictment sua sponte to prevent the third trial. The court reasoned that it would violate basic fairness to continue re-prosecuting when the government's evidence had already been rejected by 21 out of 24 jurors. The judge wrote that another trial would ignore the reasonable doubt standard. He characterized the case as useless prosecution, instead continuing to press for conviction after repeated failures was not fair play. Ingram is notable because it invokes fairness and due process. However, it remains the exception, not the rule. It's a single judge decision. It did not become binding precedent. Yeah. So basically, there are some vague musings. The Third Circuit emphasized trial courts should not have freestanding authority to dismiss indictment due to multiple grand juries, or multiple juries hung, at least not without other compelling circumstance. United States versus Wright, Third Circuit, that court held inherent supervisory power to dismiss for duplicitous prosecution exists only in narrow circumstance. Only if the government engaged in misconduct, the defendant was prejudiced, and no less severe remedy was available. But that's just generally true, for just misconduct as a general proposition, right? You don't need special things dealing with that. Prosecutorial misconduct is a crucial factor that can change the analysis. Yeah, but that has nothing to do really with, that just has to do with misconduct unto itself, really. Yeah, a deliberate attempt to get a mistrial. Yeah, we know that. Some have criticized as too narrow. Blah blah blah. Prosecutorial misconduct plays a role in courts' willingness to allow retrials in more indirect ways. Yeah. So if they fuck around hard enough, maybe. The Ninth Circuit once upheld the dismissal of an indictment after finding repeated Brady violations by a prosecutor made it impossible for a defendant to get a fair trial. So there are, some issues dealing with enough fuckery. They'll say enough. The limiting principle is dismissal only if no lesser remedy is available. So, at some point, yes. Some states, of course, give more protection, which we'll skip that because we're only interested in federal constitutional guarantee. Some decisions highlight Baucus versus Illinois. We talked about Green versus United States. Relevant double jeopardy case where the court held the government could not retry a defendant on a greater offense after implicitly acquitted of prior trial. Yeah, that's a different issue. That's dealing with by acquitting on the lesser charge, it necessarily acquits on the greater charge because the greater includes the lesser. So yeah, necessarily is true. So yeah, we know that, but that's not on point. United States versus Castellano, reversed. In that case, dealing with mistrial poses no bar unto itself. Ingram, district court we discussed. Pastrin versus Blackridge, another extraordinary case, federal habeas. Tried 5 times. The first 4 trials in North Carolina all resulted in hung juries. The 5th trial produced a conviction. Federal grant habeas relief finding the 5th trial violated due process. Part of the reason was by the 5th attempt, critical defense witnesses were unavailable, and the state court refused to assist in securing those witnesses, effectively tilting the field. Court noted the manifest necessity of securing the witnesses given the 4 prior trials and how the proceeding without them was fundamentally unfair. Yeah, but that's not based on the number of trials. That's based on the fuckery of the 5th trial, right? That's based on the fact that they fucked around at the 5th trial. Yeah. So that's really not Bluford we discussed. Renko versus Lett, state conviction after a jury deliberated only a short time. Yeah, but that's different. So in that case, the state declared a mistrial after the jury only deliberated a short term. So that dealt with manifest necessity, which is a separate issue. Because manifest necessity is not necessarily indicated by the length of time. So even if it's a short time, it may be manifestly necessary. So that's off point. And then, then there's some law review articles discussing the issue, which we sort of discussed a little bit. Under prevailing law, there's no explicit limit. So yeah, I mean that is correct. Yeah, there is no current hard cap, and courts have allowed multiple retrials, and there is no hard cap, and they don't allow retrials basically for fuckery, but that has nothing to do really with the number of trials, right? Nothing, not in and of itself. If there's sufficient fuckery in one trial, it may be a problem that prevents a retrial. And that fuckery might be over the course of a number of trials. But basically, the issue is the fuckery in its individual or accumulated form, basically resulting in a due process problem. But it has to be a lot of fuckery. And it has to be a lot of fuckery. And we're nowhere close to that in this case. We're not even close. We're not even close to the amount of fuckery that the kind of cases are talking about when you look at some of these decisions. So all that stuff. So yeah, all those things. So can I answer anything else, or should we just end the stream and call it a day? Maybe I get a nap. Is it nap time for uncivil? It might be nap time for uncivil. ChatGPT makes up information. It does make up some information, but at least some of those sites I know are correct. So I know it can hallucinate cases, but I also know that many of those citations are true. So I'll give it the benefit of the doubt on the cases I didn't recognize, which maybe is a mistake. But it's like, yeah, some of those decisions I know is correct. So, yeah. All right, guys. I'm going to go ahead and sign off for now. I'm a little tired. I'll try to get some good solid sleep and be ready for tomorrow. So, yeah. I've been on civil law. Until later, my friends. Have a good one. Cheers and goodbye.